Hello?
Place yourself on mute. Everyone, this is not the first time you're using Zoom. Let's not pretend it's the first time. All right, everyone, happy Thursday. This is the 187 District Court. Let's keep this a Thursday. Let's not try to turn it into a Monday. These are the rules of the 187 District Court. You are in a courtroom. If you're at your home, you need to find a place that's stationary. If you're at your work, you need to find a place that's stationary, and you need to tell your employer or supervisor that you need to take a break. There is to be no laying in bed. There's to be no smoking of cigarettes. There's to be no cooking a meal, changing diapers, playing with animals on this Zoom screen. Whatever you could not do if you were on Zoom, and if you were in the 187 District Court in person, you cannot do that on this Zoom screen. If you behave inappropriately on this Zoom screen, your Zoom privileges will be revoked. You will be required to appear in courtroom, and your Thursday will become a Monday, because you're either going to have to take the VIA bus, find change, take a Lyft, take an Uber. If you drive yourself downtown, you're going to find construction. You're going to find one-way streets. You're going to find difficult to find a place to park. And when you do, it's going to be expensive. So let's keep this as a Thursday and not turn it into a Monday. To all the inmates at the jail, you're not allowed to use the chat box. Mr. Delgado, if you put on a mask, wear it as a mask. Don't wear it as a chin strap. It does no good. You're not allowed to use the chat box. You're not allowed to use the internet. If you do any of those things, you will be sent back. This is not The Bachelor. This is not The Bachelorette. Nobody is allowed to use this Zoom screen to try to pick up dates. Not allowed. I'm going to open breakout rooms. When I open breakout rooms, it's going to invite you to a breakout room. Do not. I repeat, do not go to a breakout room unless I specifically call you by name and assign you to a room. To all the defendants and those who are accused, your attorney is probably going to want to go to a breakout room first and speak with a prosecutor. So please do not raise your hand asking if you should go to that breakout room, because my answer is going to be, were you called to go to that breakout room? To all those who are accused and defendants, I'm going to call your attorney's name, not your name. If you do not hear your attorney's name, it is because they are Zooming in another courtroom. Trust me, they will Zoom in as soon as they are finished with that Zoom or in-person hearing. So everyone be patient. Put some patience in your pocket. Attorneys, If you have a plea bargain agreement, no matter how small that plea bargain agreement, you need to put that in the chat box to the court coordinator. She's listed on the screen as Ferguson coordinator. You cannot chat her from a breakout room if she is in the main room. So make sure that if you have an agreement, you come to the main room, you chat her in the main room so that she can see what the agreement is and prepare the appropriate paperwork. If your client is on bond, she will need your client's email address. Attorneys, if you are looking for a reset or whatever, do not text, chat, call, phone, email Ms. Ferguson asking her for a reset. I'm the only person who can give that to you. If you decide to leave and go to another courtroom and your name is called, you will be placed at the end of the list. This is the order in which attorneys will appear. Mary Peterzak, Sharon Thorne, Linda Corley, Amir Mamori, Scott McCrum, Bill Davidson. Is there an attorney's name that I've missed? All right, attorneys, when I call your name, I need to know the name of your client. I need to know whether or not it's criminal trial division or family violence. And if you have the ability to change or add to your name, your client's name, and whether or not it's criminal trial division or family violence, that would be greatly appreciated. It will make things go smoothly. So think of those breakout rooms as going to see the doctor. When you get called to go to the doctor's office and the nurse calls you to the back, you're not seeing a doctor right away. They're just checking your blood pressure and your weight. So be patient. All right, Mary Peterzak, who do you have?
Good morning, Judge. Mr. Timothy Dean, it's a criminal trial division. This is a motion to set bond for an MTR.
I'll send you to breakout room number 2 to confer with somebody from the state.
Thank you, Judge.
You're welcome. Sharon Thorne.
Good morning, Your Honor. I have Allison Dawn Elliott or Lethisa Vasquez. She has an AKA. It is criminal trial division. She has 3 cases. I'm on 2 of them. Richard Langlois is on 1 of them. I'd like to confer, I believe it's Meredith McIntyre who has been conferring with Richard.
All right, I'll send you to breakout room number 3.
Thank you.
You're welcome. Linda Corley.
Good morning, Judge. CTD Samuel Ryle.
Thank you for changing your name. I really appreciate that.
You're welcome, Judge.
I'm going to send you to breakout room number 4.
Thank you.
Amir Mamori.
Good morning, Judge. Judge, I have Robert Andrade. It's a stalking case. I would suspect it's a family.
Okay. I will see you to number 5.
Do I go there now and wait for an ADA, Judge?
Yes.
Thank you.
You're welcome. Scott McCrum.
Morning, Judge. I have Quentin Eddington, and it's a family violence case.
I'll send you to number 6.
Thank you.
Bill Davidson.
Good morning, Your Honor. I have Michael Padilla. It's a PSI sentencing.
Right here, right?
Yeah.
You need to speak with your client.
I would like to speak to him briefly.
All right, to the courtroom. Could you go to breakout room number 7, please?
Thank you.
And I'll send you to number 7, Mr. Davidson.
Thank you.
Robert Porter, you've changed your name for me. I appreciate that.
Good morning, Judge. I'm sorry. I keep forgetting. I know you have a 9 o'clock docket, but I keep getting the Zoom for 9:30. So I'm going halfway.
No problem. I send you to breakout room number 8. All right, Mr. Orta, who do you have?
I have Delphina Spiller. It's a drug case.
Okay, just 1 second.
She has 3 new cases that are pending. That haven't been indicted. She just got charged with it.
All right, I'll send you to number 9.
Thank you.
You're welcome. All right, Michael Ruano.
Yes, ma'am.
All right, just give me a moment. All right, Mr. Ruano,
Yes, ma'am.
we have an issue. What is the issue?
I have no idea. According to Mr. Palacios, I'm doing everything I need to do. I'm doing my
Now,
classes.
what I have to date is that you have yet to make a payment on your financial obligations.
I can make one on Monday when I get paid.
All right, so here's the thing. Why do we have to have compliance hearings like we're children for me to tell you to do what you're supposed to do while you're on probation?
There's really no excuse. The only excuse that I really do have for you is that I'm barely getting on my feet. I'm not making that much. I have to pay $210 towards the GPS monitor and my classes, and also I have to pay rent. So I'm barely getting on my feet little as I'm going.
Here's the thing then, sometimes people need to take second jobs. I understand people, people think everybody's wealthy. I'm not wealthy. I understand the predicament, but
ma'am.
there are always consequences for actions. And if you're not making enough money, then that means you have to take a second job.
Yes, ma'am.
Now, should people have to take second jobs to live? No. But then who's going to be paying for that? Am I
Correct.
supposed to pay for it? Are other taxpayers supposed to pay for it? And when
No,
you're
ma'am.
on probation and when you have officers who are supervising you, they're supposed to get paid for supervising you.
Correct.
Because if they don't get paid, guess what? They can't feed their family and they're actually working a job. So can I say to them, thank you for working your job. Your payment is my thank you.
Yes, ma'am.
So you're in deferred adjudication for violation of bond or protective orders. So
Yes,
you're
ma'am.
here because you violated bond or protective orders. That's something of your own making. Now you're dealing with consequences. And consequences are, you need to start making payments towards your financial obligations.
Yes, ma'am. I told Mr.
You need to
Palacios
do you need to do your community service hours.
Yes, ma'am.
That needs to be done. There
Will
can
do.
be no excuses. Let me give you a hypothetical.
Yes, ma'am.
If I steal someone's car and wrecks it,
Correct.
and let's say that car is completely paid for, they only have liability insurance. And let's say that somebody tells me, well, Judge, you need to pay them $500 or $800 or $1,200 will make them whole. And then I say, well, I'm doing all I can. I'm working my jobs. I don't have any money to make them whole. Well, guess what? I shouldn't have stolen their car.
Correct.
So people cannot commit offenses and then say, I can't do what's required of me because it's hard on me. This is probation. There are consequences. Probation is hard on everybody. People at the Bexar County Jail can't say, I don't want to be at the Bexar County Jail because I don't want to face the consequences and I have other things that I want to do in my life. Everybody has something else they want to do, but people have to face consequences for their actions. Now, as far as community service hours are gone, I will tell you this. I don't require anybody to get the COVID vaccine. Not a medical doctor, don't pretend to be one, don't play one on TV. But if you decide to get the COVID vaccine, I have been deducting 40 hours of community service restitution. If people
I got both of my COVID things in jail, ma'am.
All right, then you need to give that to probation.
Okay.
Is there anything else?
Yes. For due to the GPS, I told them this instead of, because they want me to pay another $210, but I told them if I don't have to pay the $210 for the GPS, I could put that towards
Let me ask you this. Why do you think you're on GPS?
for violation of protective order.
Yeah, so that means that you can't be trusted because you are here for violating a protective order, which means another judge gave you an order to stay away from somebody and you continue to do it. That's why you're on GPS, so that now people can make sure that you follow the rules. If you would have followed the rules and left that person alone, then we would not be here.
Correct.
So you're on GPS because you can't be trusted to stay away from that person. And I'm just speaking truth to you. You understand?
Yes, ma'am.
I could sugarcoat it, but I'm not going to sugarcoat it. That's why you're on GPS. Because you continue, there's a protective order in place saying you're not to bother this person. You can't go near this person. And you just said, whatever, I don't care. I'm doing it anyway. That's why you're on GPS. And you're going to remain on GPS because you can't be trusted to follow the orders of leaving a person alone.
Wasn't the agreement that we had was for 60 days?
Now you're trying to
I'm
negotiate with me. Do not
No,
negotiate.
I'm asking. That's what I had signed for, ma'am. That's
No.
what I'm asking you.
No. You're going to be on GPS until I decide that you can be trusted not on GPS. The person that you were violating protective order against, obviously they're afraid of you. Obviously they don't want you around them, and you can't be trusted not to be around them. For everybody who's on here, when you're in a relationship and that person no longer wants to be with you, you need to say, thank you. Maybe we can still be friends. Maybe we cannot be friends, and call it a day. So if you would have called it a day on your relationship and not violated orders, we would not be here. But since you didn't, this is where we are, and this is what is happening. So I'm sending you to a breakout room with probation. Please do not come back here for me to talk to you about doing what you're supposed to be doing on probation. You understand?
Yes, ma'am.
I'm going to send you to breakout room number 1, and probation will speak to you about your new conditions. Mr. Rana, you need to go to breakout room number 1. And I believe he's frozen on the screen. Mr. Langlois, who's your client? You're on mute.
My client is Ellison Dawn Elliott.
All right, I'm going to send you to breakout room number 3. And Rebecca, Mr. Ruano appears to be frozen on the screen.
Okay, yeah, I'm just waiting for him to go into the room and then I'll join him.
All right, what I'm going to do is I'm going to remove him because actually he's frozen, or either he's doing a good imitation of a statue. I'm going to remove him and have him zoom back in. Bill Davidson.
Yes, Your Honor. Hi.
Hi, are you ready on Mr. Padilla?
Yes, I'm ready on Mr. Padilla. I have one letter that I was trying to get to you through Norma Ferguson on.
They did send me a letter.
Okay. And then his daughter is Esther Padilla, who's I'm going to use as a witness, a character witness.
All righty. Who is the prosecutor on Michael Padilla?
I believe it's David Martin.
Yeah, I can do it.
Let's see if this works. Brenda, I think it is working. All right, the court is calling 2020 CR 9254, State of Texas versus Michael Padilla. Can I have parties announced for the record, please, for the state,
David Martin.
for the defense?
Bill Davidson.
And are you Mr. Padilla?
Yes.
We're here for sentencing. We're proceeding by video. But for the record, I'll note that Mr. Padilla is physically in the courtroom. Any objection to this hearing taking place by video, state?
No objection.
Defense, any objections?
No objection, Your Honor.
Mr. Padilla, do you have any objections to this taking place by video?
No, I don't.
All right, and I'm gonna need you to make sure you speak up. All right, we are here for sentencing today. According to the plea bargain agreement, the state proceeded on count 2, indecency with the child exposure. The court found there was sufficient evidence to find you guilty. According to the plea bargain agreement, the state is silent on your application, and they're asking for a Chapter 62 compliance and a no contact order. And I believe that no contact order is with the complainant. Have both parties had a chance to review the PSI? State? I think David Martin is frozen in time. All righty, just give us one moment. We're gonna wait for David Barton to zoom back in. And Brenna, my real time isn't working.
Oh, hold on, Judge. Let me start it.
Okay, thank you. Tony Jimenez, who do you have? You're on mute.
I have Mr. Hinojosa. Bonifacio.
Criminal trial division or family violence?
It looks like it's probably family violence.
All right, I'm gonna send you to breakout room number 10.
Yes, Judge.
Teresa Conley.
Good morning, Your Honor.
Good morning.
I have family violence, Albert Aguirre. I sent a document to David last night, David and Joe Ray.
All right, I'll send you to breakout room number 11.
Thank you.
All right, we are back on the record, and Brenna, I do see it. All right, have both parties had a chance to review the PSI report? State?
Yes.
Defense?
Yes, Your Honor, I have.
Any objections to the PSI report from the state or the defense?
Not from the state.
Not from the defense.
All right, the state is silent, so defense, you may proceed.
Your Honor, the first thing I wanted to present was there was a letter I did send a copy to David Martin from a Mary Padilla, and that was his wife. It's a 2-page letter with maybe just like a couple sentences on the 3rd page. And
all right, any objections to the court reviewing defense exhibit number 1, state?
No objection.
All right, then defense exhibit number 1, which is a letter from Elizabeth Padilla, is admitted, and Brenna, I'll make sure to leave this on your desk. All right, defense.
Your Honor, my client is taking responsibility for his actions. He's 72 years old, as far as I understand. He's never been arrested except for this one offense, which apparently may have occurred many years past. He has told me that since then he has been a man of faith. He's gone to church quite a bit, and he doesn't believe this sort of behavior is a part of his life anymore. There's certainly no excuse for this kind of behavior, and he has been wanting to be in a situation where he could be on probation and prove to the court that he's no longer this kind of a threat. I do have an active live witness for the courtroom that I wanted to bring in, and that's his daughter. And that's Esther Padilla. She should be there or in the hallway.
All right, Deputy Laura, is there an Esther Padilla present?
I'm here via Zoom, Your Honor.
Ah,
I told her to get on Zoom, actually.
oh, no problem.
But she is in
All
the
right.
hallway.
Thank you. Ms. Padilla, if you could raise your right hand for me, please.
She was going to be in the hallway.
Yes.
You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand if you could state your name for the record and please spell it.
Esther Padilla, ESTHER PADILLA.
All right, defense.
And who are you in relation to, Mr. Padilla?
Mr. Padilla is my father, so I'm his daughter.
And how long did you live with him when you were growing up?
At least 20 years.
And during that time, did he ever abuse you in any way?
No, never.
Did you ever observe him abusing anyone else?
No.
And can you tell me a little bit about when you were growing up? Did he do anything to help out at the house, or what was he like when you were growing up?
Growing up, my house is a little non-traditional. The roles were sort of reversed for my mom and my dad. So my dad very much played Mr. Mom, the caregiver. My mom was a full-time teacher, so my dad took it upon himself to cook, clean, do laundry, make sure, handle the finances, chauffeur all of us around. He took care of anything and everything we needed.
Okay. And was he a man of faith?
He always has been and still is, probably even now stronger to this day. He now goes to church almost regularly. If he's not going to church every day, he goes to church just to sit there and pray. And if anything as well, I think through his faith, the relationship with me and my father has extremely grown. If it wasn't for his faith in helping me, I think I would have turned away from my faith as well a long time ago.
And what kind of work do you do?
I'm a specialist at HEB as a curbside or personal shopper.
Okay. And if this judge were to see it fit to put your father on some sort of probation, would you help him make his appointments and do what he's supposed to do?
Oh, of course. My father is one of the reasons why I still have my job, just because I am down to one vehicle to share between me and my husband. So whatever my father's able to do for him, I'm more than willing to do in return for him.
I pass the witness, Your Honor.
State.
No question.
All right, thank you for coming to testify.
Thank you.
So Your Honor, in sum, I'm asking for 5 years deferred on Mr. Padilla, and the evidence I've presented is all the evidence I have at this point.
All right. Well, there's an issue with the PSI report. It lists the prosecutor as Clinton Malloy, and it lists defense counsel as Jocelyn Andrews. My understanding is that Ms. Andrews has not been the defense attorney on this case. Is that correct?
That's correct, Your Honor. I noticed that is a typo, and I didn't do anything about it, but I know that both of them were not on the case.
All right. So even though that's incorrect, are both the defense and the state saying that this is still the correct PSI for Mr. Michael Padilla? State?
Yes, I believe it is.
Defense?
Yes, Your Honor. I've looked at everything else, and those are the only two mistakes. I apologize for not bringing it to the court's attention.
No problem. Then I have a few questions for Mr. Padilla. Mr. Padilla, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand. On this report, and Mr. Davidson, I don't know if you want to address this with your client, but it says guilt minimized.
I had addressed that prior to the report, Your Honor. I had found that many of my clients would talk about their cases and tend to minimize the situation, and I always tend to warn them against doing that. I'm not sure exactly how he may have minimized it in this particular case.
All right. And the other issue the court has, and I don't know if you want to address it with your client or not, is that the complainant says, I feel like the black sheep in the family for being the whistleblower, that she's being treated differently because she came forward with this allegation. And she says, in their eyes, I shouldn't have reported it and should have swept it under the rug so the skeletons don't come out. So I want to know, has this complainant been ostracized from the family? Because this defendant who's on the screen is her uncle by marriage.
I would have to ask him, Your Honor. I did read that. I wasn't sure exactly.
All right, would you like to question him about that?
Yes. Mr. Padilla, this is your attorney, William Davidson, and the judge is talking about a statement inside of the report that has to do with the victim in the case feeling as if she's been ostracized or put out of the family or somehow maybe been the cause of some problems in the family. Can you speak to that issue or tell us anything about what you might know about that?
I don't know what ostracized means.
Ostracized means to put out. In other words, she's feeling like she was blamed for something. I think that's what she means. Do you understand what that is?
Who was blamed? Me or Melanie?
She says that she feels like she's being blamed because she brought this issue up.
Oh,
do you know of
okay.
anyone who has gotten after her or blamed her for bringing this up?
No, I don't. Not that I know of. I don't blame her for anything.
Well, I know you don't, but do you know anybody in your family that may have blamed her or brought it up or anything like that?
Not that I know of. No. If they mention anything, it would be to me, but not to her, because we haven't spoken for years. So no.
Okay. Do you want me to continue to question on that, Your Honor? I don't.
Oh, no, that's fine. Mr. Padilla?
Yes.
Has the family talked to you about this?
So, well, we've talked about it, it's painful for everybody.
Well, has it been painful for you?
Well, of course. I mean,
how so?
If there was a magic word like I told the officer last week to change all this, I would, because I feel for her, I feel for the family. And like I told the officer as well, I wish her all the best in the world and a very bright future for her.
No. My question is, how is this painful for you?
Well, it just hurts. I mean, I don't know how to put it, but it hurts a lot. I mean,
but why does it hurt you? That's what I'm trying to understand.
I can't hear what?
Why does it hurt you?
It hurt a decent human being.
Yeah, ma'am, I don't know if this is out of place, but is it possible that he could just remove his mask so we could hear him better just for a few minutes?
Yes.
Thank you. Take your mask off for a minute.
Okay.
The judge wants to know, why is this hurting you? How do you feel about this?
Because it hurt Melanie. She's a decent human being, and there was no call for it.
And Mr. Padilla, what were you thinking when you were committing these acts?
It's obvious, Your Honor, I wasn't. If I had been, none of this, we wouldn't be here right now.
Okay. All right. The court will, you can put your mask back on. The court will hear argument. Defense?
Yes, Your Honor.
Silent.
Yes, Your Honor. He's shown some remorse here. I don't know exactly what issue was, how the guilt was minimized. I do know that he has admitted to this, at least in this courtroom and on paper, and he's told you that he feels badly about it and that he wished it had never happened. And I know there's two ways to read that. One way is to read, I wish it had never happened because I didn't get caught. And then the other way is to read it, I wish it had never happened because I feel bad about it. And it seems like he's trying to say the latter of the two. His daughter has stated that at least during the time that she was brought up by him, he seemed to treat her right. And there's a letter from his wife, which speaks well of him, without saying that he's an angel or anything like that, that would, trigger the state having to come in and axe the whole thing. I respectfully ask the court for the deferred because he's 72 years old. And if he messes up, if he does anything wrong, he can be pulled right back in. He can be given many more years that would equivalently be life.
All right. All right, Mr. Padilla, the complainant in this case, when this started, according to the PSI report, was 4 years old, which is an extremely vulnerable age. And what I'm reading in the PSI report is you and your wife took care of the complainant. The complainant was picked up. You took her to a shed, unzipped your pants, did something into a handkerchief and put it back in your pocket. And that's her first memory. And then it goes on to describe other actions by you throughout her childhood. I'm going to deny the application. I'm going to sentence you to 4 years in prison, give you credit for any time served, Chapter 62 compliance, and there's to be no contact with Melanie Salazar. Show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? Mr. Padilla, did you review that document with your attorney and did you understand it?
Yes, thank you.
All right, because this is plea bargain agreement, and actually, because I followed your plea bargain agreement, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
And you will have to register. All right, if there's nothing else, the court will close the record.
We just have victim impact, Judge.
Okay. There's victim impact. Ms. Salazar, if you could show your video, please. All right, Mr. Padilla, Ms. Salazar has some things she wants to say to you. I require that everyone treat everyone with respect in this court, so please listen to her and internalize what's being said. Ms. Salazar?
This is going to be really hard for me to get through, so I'm going to try to be as brave as I can. So I believe that hurt people hurt people. So I first want to say that to Michael Padilla, I'm sorry for all the pain that you have experienced. The pain and trauma that you've caused me is my deepest wound and the heaviest cross I have to bear. The things you did to me, no human should ever experience. Yet I did. I did experience all the hundreds of times you committed sexual violence to me. And I forgive you. From the time of about 3 years old until 11 years old, my life will never be the same. Still, I forgive you. And I want you to know that it is not the cause of me reporting you that has placed you where you are today, but it is the cause of your sins that did that. It is because of your sins. God is a just God, and I believe that is why we are here today. It is God's justice. And if it is not served in this life, I believe he will serve his justice to you in the next. However, God is not only a just God, he's also the God of mercy. And I cannot forgive you by my own human power. It is through Jesus Christ and his example of mercy that I can do this. I want to share with you the story of my favorite saint, Saint Maria Goretti. She especially inspired me to forgive you. Saint Maria Goretti was a beautiful young girl. Her father died when she was young, so in order to pay for the rent of the house, her family had to share the household with another family, the Serenelli family. The oldest son, Alessandro, would make sexual advances on Maria. Out of fear of him hurting her family and her family not helping and her family not having the help to pay for their land, she did not tell anyone. One day, Alessandro tried to rape Maria. She begged him not to and said that it was a sin against God. Maria said she would rather die than sin against God. She got on her knees and prayed. He proceeded to stab her 14 times. Maria was able to crawl and get help. And before she died, she shared what Alessandro did. And her last words were, "I forgive Alessandro. I love him. And I want him in heaven with me." And I too, inspired by Saint Maria Goretti and led by Jesus Christ's mercy, I forgive you, Michael. I forgive you. I love you. And I want you in heaven with me. And a beautiful part of the story is what happened after Maria's death. Alessandro spent many years in prison, and a few years into his sentence, he accepted the endless mercy the Lord offers. He sought forgiveness, he repented of his sins, and he changed his life. He finished the rest of his sentence in tranquility. Shortly after his release, he sought out and received the forgiveness of Maria's mother. He eventually joined the Capuchin Franciscans as a lay brother. After he died, the friars found a sealed envelope. It was his spiritual testament, written in the form of an open letter to the world. It contains an appeal that all follow the way of Christ. It also paints a dramatic and touching picture of a man who was able to regain his dignity through the generous mercy that those he wounded extended to him. And here is Alessandro's open letter, the abuser and attacker of Maria Goretti. I am now 80 years old. I'm close to the end of my days. Looking back at my past, I recognize that in my early youth, I followed a false road, an evil path that led to my ruin. Through the content of printed magazines, immoral shows, and bad examples in the media, I saw the majority of the young people of my day following evil without even thinking twice. Unworried, I did the same thing. There were faithful and practicing Christian believers around me, but I paid no attention to them. I was blinded by a brute impulse that pushed me down the wrong way of living. At the age of 20, I committed a crime of passion, the memory of which still horrifies me today. Maria Goretti, now a saint, was my good angel with whom God placed in my path to save me. Her words, both of rebuke and forgiveness, are still imprinted in my heart. She prayed for me, interceding for her killer. 30 years in prison followed. If I had not been a minor in Italian law, I would have been sentenced to life in prison. Nevertheless, I accepted the sentence I received as something I deserved. Resigned, I atoned for my sin. Little Maria was truly my light, my protectress. With her help, I served those years in prison well. When society accepted me back among its members, I tried to live honestly, with angelic charity. The sons of St. Francis, the minor Capuchins, welcomed me among them, not as a servant, but as a brother. I've lived with them for many years now. Now I look serenely to the time in which I will be admitted to the vision of God, to embrace my dear ones once again, and to be close to my guardian angel, Maria Goretti, and her dear mother, Assunta. May all who read this letter of mine desire to follow the blessed teaching of avoiding evil and following the good. May all believe with the faith of little children that religion with its precepts is not something one can do without. Rather, it is true comfort and the only sure way in all of life's circumstances, even in the most painful. Peace and good to all. Alessandro Serenelli, May 5th, 1961. Maria did become a canonized saint in the Catholic Church, and the story goes that Alessandro was there the day of her canonization. Currently, Alessandro Serenelli is in the process of becoming a saint himself. And to my Uncle Michael, who abused me all my childhood, this is my prayer for you. Through the example of Alessandro, I pray that you too will repent and seek the Lord Jesus Christ's mercy, his divine mercy that is endless, constantly calling out to us and waiting for us. All the sins in the whole world, from the beginning of time to the end of time, are but only a drop in the ocean of God's mercy. And all the sins that you have committed, specifically all the sins you committed against me, are still just a drop in the ocean of his mercy. Since I first reported my abuse in December 2019, unto this point, this has been the most difficult experience of my life. I pray that after today, I pray that after today, I can begin a tremendous healing journey. Hopefully, one day, my family will have peace, be redeemed, be restored, and will accept me fully again. And I pray that you will convert and come back to the Catholic Church. I pray that all the days of your life, Saint Maria Goretti, Alessandro Serenelli, Saint Michael the Archangel, Saint Joseph, the foster father of Jesus, and the Holy Mother of God, Mary, ever Virgin, will watch over you and lead you to Jesus. I ask all these things through the intercession, through the power of the Holy Trinity, in the name of Jesus Christ, and sealed by the precious blood of Jesus. Amen. Jesus, I trust in you. Thank you.
All right, thank you so much. All right, Mr. Padilla, good luck to you. Thank you, Mr. Davidson.
Thank you, Aaron. Thank you, David. May I be excused?
Yes.
Thank you.
Okay. Linda Corley.
Yes, Your Honor, I have conferred with Marcus, and I've got some information I'm going to try to get to him. He's going to talk with the complainants, and if we could get a reset.
All right.
My client, I know it's an older cases. Samuel Ryle, R-E-I-L-E. He was had competency counseling in his and now we're back in your court, so we just started the process.
All right, and was a determination or disposition on the competency matter handled?
Yes, it was. He was found competent at this point, and so now we're moving forward with the cases.
All right, and in which You say cases, is there more than one case?
He has some misdemeanor cases, Judge. This is his only felony case.
All right, and how much time did Marcus say he need?
Actually, I didn't ask him. I just assumed 30 days. I don't know if he's available or he might be in a breakout room.
All right, so this is what the court has discovered. Usually what ends up happening is once people are restored to competency, then things happen and they decompensate. So Marcus Sanders, are you here?
Yes, Judge.
How much time do you need on this case?
It doesn't matter for me, Judge. I think Linda's thing may take a little bit longer as far as gathering the documents and stuff.
Now, I've got to get some other court documents, Judge, from other jurisdictions, and I only have one of the case numbers at this point.
All right. Norma, can you give them a 3-week reset and Ms. Corley, we'll see where we are at that point. I just don't want your client to decompensate.
Yes. Okay. Will I receive that in email or did you want to give
No,
that to me?
you're going to get a date right now.
Thank
I'll
you,
give it to
Judge.
you just 1 second, Linda. We can do the 27th.
Right.
The 27th or the 24th, Linda?
Now let's just do the 27th.
All right, we will see you on September 27th at 9 a.m. The court will have that by Zoom. Do you need to speak with your client?
No, Judge, I can call him if we can both be excused. I've got to go to another court right now.
Yes, you're excused.
Okay. Samuel, I'll call you later this afternoon. You can leave the meeting. I don't know if you can hear me.
Yes.
He did. Okay. Very good. Thank you, Judge.
You're welcome. Sharon Thorne and Richard Langlois, what is happening with Miss Elliott?
Your Honor, we've conferred with the state and also with our client. The state is going to offer her probation. They're going to do a probation on the theft case, which Richard represents her on. And in return, they're going to dismiss the 2 cases.
I'll just put it in the chat box.
Oh, okay.
Yes.
But real quick is, Judge, I have to go report to another court and Richard's going to be handling the plea. May I be excused to go report to another court? Thank you.
Yes. All right, and then Pat Hancock, you're back on Mr. Jimenez.
Yes, Your Honor, thank you.
You're welcome. The court is calling 2020 CR 4098B, State of Texas versus Wilson Daniel Jimenez. Could I have parties announced for the record, please, for the state?
Tom Nisbet.
For the defense?
Pat Hancock.
And are you Mr. Jimenez?
Yes, Your Honor, I am.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
No, Judge.
Any objections from the defense?
No, Your Honor.
Mr. Jimenez, do you have any objection with this hearing being continued by video?
No, Your Honor, not at this time.
All right. This was recalled today to give the court a chance to review the exhibits that were submitted by the state. The court remembers all of the testimony and the court has reviewed the exhibits admitted by the state. Any final argument before the court makes its ruling from either the state or the defense?
Not from the state, Judge. No, Your Honor.
All right. After reviewing state's exhibits and hearing all testimony, the motion to reduce bond will be denied. Mr. Hancock, do you need to speak with your client?
Yes, Judge.
All right, I'll send you to breakout room number 1.
Thank you.
You're welcome.
And Judge, can you just make sure that they get back so I can release them from the main room?
Yes. All right, Tony Jimenez.
Judge, you sent me to a breakout room. I've been waiting and waiting and nobody's.
Oh, you missed my speech at the very beginning. Those breakout rooms are like going to a doctor's office. When the doctor calls you back to the breakout room, they're just checking your weight and your blood pressure. It's a part of the process. So the state can see you in the breakout room.
Okay.
And there is an order. So you were in breakout room number 10, which means there were 9 other people before you.
Okay,
but they're making their way throughout the breakout rooms.
okay,
So if you'll go back to breakout room number 10, and
yes.
if there is, let me start, just one moment. Let me
Can I have a drink?
up a little bit, please? Just 1 second.
Water's fine.
So family violence, Scott McCrum is in breakout room number 4 on Eddington. John Coots is in number 5 on Manuel Martinez. Robert Porter is in 6 on Angel Delgado. And Tony Jimenez, I'm going to move you up to 7.
Thank you, Judge.
There's movement.
All
Richard
right.
Lang, yeah, Richard
Yeah,
Langlois.
this is David. Can you make me a co-host again? I had to switch devices.
Yes.
Thank you.
Mr. Langlois, my understanding there's an agreement. So you will be getting paperwork.
Right. It's on there. It's a multi-count indictment with a plea on one
Oh,
case.
no, Sharon Thorne has already told us, and that information is being sent to Ms. Ferguson.
Yeah, and she's done because her 2 cases are being dismissed.
Okay, thank you. Charles Bunk, I'm going to send you to breakout room number 8.
Okay.
Scott McCrum, you've left the breakout room. A prosecutor is headed your way.
Thank you, Judge.
You're welcome.
Judge, it's Teresa Conley.
Yes.
Mr. Garcia has decided to withdraw the MTR. He's there. But I don't think his sound is on.
Is that correct, Mr. Garcia?
Yes, Judge, and I just sent a text to Rebecca, letting her know the reason. He's been in continued custody.
Okay.
So Mr. Gary should get out soon.
He probably won't be released until 1 a.m.
Thank you, Your Honor.
Where's Mr. Aguirre? You need to unmute.
The space bar?
You need to unmute. Mr.
Yes, ma'am.
Aguirre, when you get out, you need to make sure you follow all conditions. You understand?
Yes, ma'am. Yes, ma'am.
If you do not, a motion to revoke may be filed, and you're charged with assault family second offense. The range of punishment for that offense is up to 10 years in the prison. You understand?
Yes, ma'am.
So from here on out, every decision that you make, you need to ask yourself, is this a decision that could potentially result in me going to prison for 10 years? You understand?
Yes, yes, ma'am. I do.
All right, Rebecca, on this case as well, if he does the COVID vaccine, then you can deduct 40 hours from community service restitution. And again, I'm not forcing anyone to get the COVID vaccine. You can get it or not get it, but if you do get it and you provide proof that you successfully completed it, then you will have 40 hours deducted from your community service restitution. Rebecca, do you need to see him in the breakout room?
No, ma'am.
All right, Norma, can you let them know L11 can go back? And
Yes,
Ms.
ma'am.
Conley, you're excused.
Thank you, Your Honor. Thank you,
You're
Mr.
welcome.
Garcia.
Teresa.
All right. Roland Garcia, who do you have? You're on mute.
I have Nancy Gonzalez, off docket matter, Your Honor. I had filed a motion to set bond to refresh your memory a little bit.
What's the cause number?
I'm sorry, 2021 CR 2979. The court had referred Ms. Gonzalez to a drug court.
Yes.
She had been evaluated. The latest update I have, Your Honor, is that she has been, she qualified, but she's
On the wait list?
perfect, thank you, on the wait list. And I got attached to my motion, some correspondence from the drug court and the additional notes reflect, please do not keep client in custody awaiting
I've
FBC.
reviewed that.
I know it's not binding on the court, but
Yes.
I'd like to think it might nudge the court a little bit to consider that possibility.
All right, so what? All right, to the clerks, could I please have the court's file on Nancy Gonzalez, 2021 CR 2979. Roger Perez, who do you have?
Judge, I represent Tyrese Hilliard-Smith. We have an agreement this morning. We've had some logistical problems with Tyrese, but he's resolving it by coming to my office. And so we anticipate being before you for a plea soon, Your Honor.
Okay, what is his name?
Tyrese Hilliard-Smith. The case is 2020 CR 5438 and 5441.
All right,
So
thank
hopefully
you.
we'll be back with you in a little bit. Thank you.
All right,
Judge.
thank you. Let me find the motion on this. You said he filed the motion.
Judge, I have it on you should have it on your credenza. I left it there.
Okay, thank you.
Judge, can I see you in a breakout room really quick?
Yes, everyone, just give me a moment. Rebecca, I'll meet you in breakout room number 2.
Okay.
All right, Roland Garcia.
Yes, sir.
Hi. The court had already heard this matter, and this matter was brought to the court's attention on August 31st. So your client was already released on August 31st.
Judge, you're always 5 steps ahead of me. Thank you very much. I appreciate it.
No problem, but what I did order is that she was to do the intensive outpatient treatment through probation. And she is going to be doing the UA hotline, and she's going to report to probation twice a month until there's a space available for her in felony drug court.
Fantastic.
And if she's doing well, I can reevaluate whether or not I place her in felony drug court.
Thank you, Your Honor. Thank you for taking the time to explain that in detail to me. I appreciate it.
All right, you're welcome. Have a great rest of your day and have a great
You too.
weekend. Be safe.
Thank you, Judge.
Judge, this is Amir. May I approach?
Yes, just give me one moment, please.
Yes, Judge.
Can I see one of the clerks in the breakout room, please? Breakout room number 2. And Rebecca, if you could go to number 2 to make sure that that was placed in the system.
Yes, ma'am.
Thank you. All right. Mr. Mamori?
Yes, Judge. Judge, may I confer with my client, Robert Andrade? He should be, I believe he's in the red shirt.
Okay, let me find him on screen. Thank you. All right, if you will go to breakout room number 4, Mr. Andrade.
Thank you, Judge.
You're welcome. Scott McCrum.
Yes, Judge. Joe Ray and I conferred. If you would give us a regular reset. I'm still reviewing discovery and he's going to give me an offer on the next setting or before the next setting.
All right, Norma, on Eddington, if you could give them a 30-day reset, please.
Yes, ma'am. Give me 1 second. We can come back on the 7th of October.
All right, we'll be back on October 7th.
Very good. Thank you.
Thank you. You are excused. And was your client on bond?
He is on bond and he's on the screen. I can see Quinn Eddington.
All right, Mr. Eddington.
Yes, ma'am.
Yes, you're excused. The next time you come on Zoom, you need to make sure your video remains on. Do you understand?
Yes, ma'am.
All right, you're excused. We'll see you back on October 7th by Zoom.
Thank you.
You're welcome.
Your Honor, this is William Davidson. I had a second case in here today I'd forgotten about. It's
No problem.
Joshua Jackson, he's in jail.
Is it criminal child division or family violence?
It's criminal trial division.
Okay, I will send you. Let me see what breakout room we have. To breakout room number 9.
Thank you.
You're welcome.
Judge, this is Horta on Spiller. I've conferred with the state. They made an offer, but they say
No,
it's
no, no. Here's the thing. No. I don't want to know what the agreement is.
No, I wasn't gonna say that.
Okay, thank you.
There's an expiration date on it by this coming Friday. But I just got retained. Hopefully we'll confer the next setting. I'm gonna ask the court for another setting on it.
All right, who's the prosecutor on this?
Hunter.
Okay. Hunter, are you there?
Hello, no one is available to take your call. Please leave a message.
Let me see. Hunter may be in a breakout room. He's in a breakout room. As soon as he comes out of the breakout room, I'll take that matter up.
Thank you, Judge.
You're welcome. Miguel Hernandez, who do you have?
Good morning, Your Honor. Mr. Deary, Donald Deary, if I could speak to a CTD prosecutor on the matter.
Okay. I will send you to breakout room number 2.
Thank you, Judge.
And Norma, if you could check, there is an inmate in number 3 by himself. That's Richard Langlois' client. And that's supposed to be a plea, but that room is, it only has the inmate in there. Victoria Cruz, who do you have?
Good morning, Your Honor. We have Orlando Armas Ramirez, and we are ready to plea. I'm emailing Hunter and Norma my email address and the defendants, but we are hoping to close that out today.
All right, thank you.
Yes, Your Honor.
We haven't seen you in a while. Usually you're always here.
I've been out of county a lot. Believe it or not, a lot of those counties are still in person. So I just got back from Atascosa. That's why I was late. I'm sorry.
Oh, no problem.
Thank you, Your Honor.
You're welcome. Do you need to be in a breakout room with your client?
We can get that process started. Yes, Your Honor, please.
All right. I'm going to send you, let me see what breakout room is open. I'll send you both to breakout room number 11.
Thank you.
You're welcome. And excuse me, L21, are you Nancy Gonzalez?
Yes, ma'am.
All right, does someone want to explain to me why she's still in custody when the court ordered her to be released? And that's from August 31st, and now we're September 9th. I'm sorry, September 2nd.
Judge, it's probably from drug court. Wasn't it a hold from drug court?
No, I ordered that she was to be released and that she was to be placed on outpatient treatment, intensive outpatient treatment with probation, and that she was to do the UA hotline and report twice monthly. Ms. Gonzalez, I'm going to send you to a breakout room with probation.
Yes,
so you'll
ma'am.
know what needs to be done, and you should be released no later than today, okay?
Yes, ma'am. Thank you. I appreciate that.
You're welcome. Rebecca, if you could go to breakout room number 3, please.
Yes, ma'am.
And Ms. Gonzalez, I'm going to send you to number 3.
Yes, ma'am.
Judge, it's John Kuntz when you have a moment.
Yes.
Can you put me in a breakout room with my client, Manuel Martinez?
All right, Manuel Martinez, can you raise your hand for me, please?
I see him on the screen right there.
Thank you. I'm going to send you to breakout room number 5. It should pop up on your system.
Thank you.
Norma, can I see you in breakout room number 12?
Yes, ma'am.
All right, thank you. Charles Bunk, you're back?
Yes, Judge, I'm back.
Yes. What's
I have
happening?
I have high blood pressure and I'm overweight.
Well,
So-
did they tell you to start eating oatmeal and exercising more?
Yeah, Marcus mentioned exercise and I hung up on him. No, Marcus made us a very fair offer. However, my client is not inclined to take it. So she remains in custody and I'd like to get on your trial list when and if we ever start doing that again.
All right, so this is what I do. I'll note that an offer has been tendered. Do you have all the discovery?
I do, yes.
So I always give people a plea deadline date. Where's Miss Bagley?
She's probably still in the breakout room.
All right, can you have her come back to the main room for me, please?
Yes, I will do my best. Let me see
Thank
if I
you.
can grab her.
All right. Bagley. And Norma, on Bagley, can you give me a 30-day reset date? And that's just going to be a plea deadline date.
It'll be October 7th, Judge.
Okay. All right, and Ms. Thorne, you are back. Mr. Langlois is waiting on paperwork.
Oh, okay. I was just gonna hang around to see because once you finish everything, Your Honor, my 2 cases will be dismissed. So I don't know if you still need me to hang around or what.
You just want to, a lot of people love hanging around in the 187th. We appreciate that.
I'll just hang around for a little bit, Your Honor, and then
okay.
If it gets to be really long, I may log off, Your Honor, because there are some other things I need to do.
Okay.
All right, I'll go mute.
All right, thank you.
Judge, this is Amir. May I approach?
Yes.
Judge, on Robert Andrade, Judge, he's on GPS, and he's telling me that at this point, he's basically homeless and can't afford the monthly GPS fee. Is there any way that the court can waive his GPS fees, Judge?
Well, let me tell you what I tell everyone. I can say waive fees. They're going to tell me that they're third-party contracts, so I have no control over that. And then I'm going to put down to place them to defer the fees or place them on indigent status. I'm trying to do some research because supposedly there is one GPS monitor that you can have for free. And I'm trying to see if that's actually the case and where is this monitor, because supposedly it exists, but no one can tell me who is on it and where it is. But your client, is he?
He's in the breakout room, Judge.
All right, has he been indicted or no?
It has, Judge. It's been indicted, yes.
Okay, I'm trying to find, it's Andrade. I
Andrade, yeah. It's a stalking case.
I can see about that, but here's the issue. It's stalking, so he's going to have to be on GPS.
I've made that very clear to him, Your Honor, that GPS is not going to be taken off because of the charge.
All right, if you could have him come back into the main room, we'll see what we can do.
Yes, Judge.
All right, thank you. Ms. Bagley, it's the court's understanding that you are requesting a jury trial. The way the process works in this court is I give everyone a plea deadline date so that people can have a chance to think about offers that have been extended. And then if you decide that you do not wish to accept that offer, then you will be given a trial date. So we're going to come back on October 7th. That's your plea deadline date. At that time, you can accept or reject the offer. If you decide to reject the offer, the court will not consider any further plea bargain agreements. If you decide to enter a plea after that date, it will have to be open to the court. Do you understand?
Can you repeat the last part, please?
Yes. All right, October 7th.
Yes.
That's the date. You need to let the court know whether or not you're accepting the offer that has been extended by the state. Do you understand?
Okay.
No, do you understand?
No, I don't, but
all right, well, let me explain it to you this way. I don't want to know what the offer is. The state has made an offer to you, correct?
The state, They had made the,
right,
if I was
Mr. Blunt,
guilty,
would you-
yeah, no,
Mr.
so
Blunt, would you like
I've
to
been
speak
doing,
with
look,
her?
miss, I've been going through this thing too long and I don't understand
Time
why
out,
it should
time
have,
out,
it should have been
time
done
out,
a long time
time
ago.
out. Charles, do you want to speak to your client about the plea deadline date and what that means, please?
Yes, yes, Judge.
All right, I'll send you to breakout room number 6.
Thank you, Judge.
Judge, this is Amir.
Yes.
Mr. Andrade is back here, Judge. He's in the red t-shirt, red shirt.
All right, just give me 1 moment.
Yes,
John
sir.
Koontz,
Yes, Judge.
on Martinez.
Yes, we have come to an agreement with the prosecutor for a bond reduction.
All right, if you all will send that to me in an email.
Yes, ma'am.
Include the prosecutor in that, what the agreement is, and the court will sign it.
Yes, ma'am. You just want an email? You don't need a motion or anything?
If you, I always.
I
I
filed
always-
the motion several weeks ago. Yeah.
Yes, I have the motion, but I would, of course, prefer if you would all do an agreed order and do it formally and send it to me. But if you all are not able to do that, if you just send me an email, what I'll do is I'll attach the email to the motion that you have filed.
Perfect. I will do that right now, Judge.
All right, thank you. If there's nothing else, then you are excused. And that will
Nothing
be in
else.
the system today.
All right. Appreciate it, Judge. Thank you. Take care.
Welcome.
Bye-bye.
Judge,
Just 1 moment. First, it's going to be Amir Mamori. Then it'll be Ramondo Orta, and then Mr. Jimenez, and then Ms. Cruz. All right. Mr. Andrade. The court understands that you have issues with paying GPS. To the courts, could I have a B page on Robert Andrade? It's 2020 CR 1052. Mr. Andrade, I will ask that the fees are waived. For your GPS. Mr. Mamori, what is happening with his case?
Judge, I have conferred with Assistant DA Joe Ray Garcia, Judge. He has given me an offer, and I've talked to my client about that, Judge, and we need to have a few more weeks to really digest the offer and make a rational decision. I don't think we can make one at this point.
All right. Have you received all the discovery?
Judge, I have received a fair amount of discovery. I don't know if it's all of it, but it gives me a basis to make a decision with my client at this time.
All right. And with regards to your client, if I give him a 30-day reset as a plea deadline date, is that enough time for you?
I believe so, Judge. Okay.
All right. Norma, can I have a 30-day reset on Robert Andrade, please?
I can do October 7th, Judge.
All right. Is October 7th a good day for you, Mr. Mamori?
Judge, it is for me. Thank you.
You're welcome. Mr. Andrade, we're going to come back on October 7th. That's your plea deadline date. What that means is the state, my understanding, has tendered an offer. You will have to let the court know on that date whether or not you accept that offer. If you decide to reject that offer on that day, the court will not consider any further plea bargain agreements. The court will only consider pleas open to the court. Do you understand, Mr. Andrade? If you could unmute for me, please. All right, Mr. Andrade, just raise your hand if you understand what I've said to you. All right, thank you, Mr. Andrade. You're excused. Thank you, Mr. Mamori, and I've signed that order with regards to the GPS fees.
Judge, I appreciate the court's time. Take care. Thank you.
Thank you. Bye-bye.
Bye-bye.
All right, Raimundo Orta.
Yes, Judge.
Yes.
I had asked the court, this is I just got retained and he just got out of.
No, I understand that, but I'm waiting for the prosecutor to come in so I can give a date to you and a date that makes sense. I don't want to call somebody back in 2 weeks and then people are not ready in 2 weeks. So just give me a moment. The prosecutor is in a breakout room. As soon as he comes back, we'll let you know. Mr. Bonk, did you explain things to Ms. Bagley?
I did, Judge, and she, on her behalf, she'd like me to ask you to just consider today her plea refusal date so she can expedite her process.
All right,
So
thank you. Ms. Bagley, we're going to come back on October 7th.
So you denying it? Are you denying it?
I'm telling you, you're coming back on October 7th.
Okay.
Now, if you would like to have a bench trial, you can discuss that with your attorney and with the state.
Excuse me?
I'll talk to her, Judge.
All right, thank you. Do you want to speak to her in a breakout room or do you want to speak to her off docket?
I'll speak to her breakout room, please.
All right. I'm going to send you out to breakout room number 5.
And may we be excused from there?
You have to bring her back in the main room to be excused.
Okay, thank you.
You're welcome. Robert Porter.
Thank you, Judge. Can I speak with Mr. Delgado briefly, and then we'll be ready for our hearing?
All right, and Mr. Delgado, is he in custody?
Yes.
All right, Mr. Delgado, I'm going to send you to breakout room number 6. Tony Jimenez.
I just need your permission to go to the 290 at the enter a plea.
All right, yes.
I'll return. Thank you, Judge.
Thank you. Victoria Cruz.
Sorry, Judge. My client is gonna need an interpreter and he's got terrible signal. I'm hoping that I can at least fill out the paperwork with him, but I just wanted to let the court know of that. Otherwise, we're ready.
Okay, thank you.
Yes, ma'am.
All right, Charles Blanc, you've been sent to breakout room number 5.
Yes, Judge, I was just chatting with Marcus to see if before I talked to my client in great detail, if this was something the state would even be interested in. So I'm waiting I'm waiting for his response on the chat. Then I'll go.
All right. Okay, thank you.
Thank you, Judge.
You're welcome.
Judge Bagley needs to go back to the breakout room. Bunk is waiting.
All right, Ms. Bagley, go to breakout room number 4, please.
May I approach, Your Honor?
Yes, Mr. Garcia, I'll see you in breakout room number 1 with probation.
Thank you.
You're welcome.
You're too fast for your staff, Judge. You signed that order on the 31st, but it's my understanding she's still in custody.
Yes.
She just went there.
All right, everyone, let me just check my paperwork. Bill Davidson?
Yes, Your Honor. Hi.
Yes.
I talked with Hunter Morris, and I just need to talk with my client, Joshua Jackson, and see if he wants to do the plea.
All right, Mr. Jackson. Let me see. I'm going to send you to breakout room number 7. Charles Bunk?
Yes, Judge, we'll come back. She is requesting a jury trial, so we'll have to come back on October the 7th.
All right, thank you. Norma,
Thank you. May I be excused?
Yes. And
Thank
Norma,
you.
can you let them know that Bagley 13C can go back?
Yes, ma'am.
Thank you. Roland Garcia, you're back with us?
Yeah, I didn't know, I didn't pick up. Did you want me to go to a breakout room, Your Honor?
Oh, no, it's, we're done.
Okay, thank you.
All right,
Just
thank
double
you. Have a
checking.
great rest of your day.
You too. Bye-bye. Thank you.
Bye-bye. And Hunter, are you here? Hunter Morris?
I'm here now, Judge.
Oh, thank you.
Yes,
And
ma'am.
I didn't even call your name 3 times. It is on Ramondo Orta's client, Delfino Spiller.
Yes, ma'am.
He said that you were giving them a deadline.
I did. I gave him until September 10th.
Okay. All right, Norma, on Delfina.
Yes,
Can we
ma'am.
have them come back for an update on September 10th? Is that doable?
Sure, I can make it work.
All right, thank you. All right, the person there for Mr. Orta, let him know his client, Delfino Spiller. Could you unmute for me, please?
Yes, let me get him. He just stepped away, Mr. Orta.
All right, thank you.
Yeah, no problem.
Judge, did you have anything else for me?
No, that would be all.
Okay, I'll be in 10 if you need me.
All right, thank you. And Rebecca, I found the motion to withdraw on Timothy Dean. I didn't know if you need to speak with him.
I already spoke with him.
All right, thank you. So that's been signed.
He's coming.
All right, thank you.
Yeah, I got it. Hello?
Hi, Mr. Orchard, your case is being recalled for September 10th.
Okay, thank you, Judge.
All right, you're welcome. Have a great rest of your day.
Likewise, thanks. I will see you.
All right, bye-bye.
Bye.
Ms. Spiller, you'll need to be here on Zoom on September 10th. And next time you're on Zoom, your video needs to be on the entire time. Bill Davidson?
Yes, Your Honor, my client does want to take the plea offer offered by Hunter Morris. I didn't know if you wanted to do the paperwork today or another day.
Oh, no, we'll do the paperwork today.
Okay.
Norma,
Yes,
the
ma'am.
minutes 14J, go back.
14J, thank you.
Yes.
Your Honor, Richard and his client should probably go back to the room to discuss the paperwork.
All right, let me see. Who is his client?
Allison Elliott.
Let me find Elliot. Elliot, I'm sending you to breakout room number 4. Richard Langlois, if you can go to number 4, please. Sharon Thorne, I'll assign you to 4 as well. Norma, I haven't seen Miguel Hernandez. Did he leave? He's in breakout room number 2. Has anyone conferred with Miguel Hernandez on Donald Deary, its criminal trial division? And everyone just give me a All right, Mr. Porter?
That's me, Your Honor.
Yes. On Delgado?
Yes, sir. Yes, ma'am, I'm sorry.
That's okay.
Yes, he is a sir. Yes. We're ready for a bond reduction hearing, Judge.
All right, who is the prosecutor you were conferring with?
It's David Martin.
All right, David Martin, are you ready to proceed?
Sure.
Brenda, each time it works, I hold my breath because I'm waiting.
Same.
But hey, it's working. All right, the court is calling 2019 CR 12079, State of Texas versus Angel Delgado. Could I have parties announced for the record for the state?
David Martin.
For the defense?
Robert Porter.
All right, and are you Angel Delgado?
Yes, Your Honor.
We're proceeding by video. Any objection from the state?
No objection.
Any objections from the defense?
No objection, Your Honor.
Mr. Delgado, we're proceeding by video because of the pandemic. Any objection to this hearing taking place by video?
No, Your Honor.
And I'm going to mute you on your end, Mr. Delgado, because we get a lot of noise from the other people there. But if anyone needs testimony for you, or if you have any questions or need to say anything, just raise your hand. I'll be able to see you and unmute you.
Okay, Your Honor.
All right, state the defense has filed a motion requesting a reduction of bail. Did you have a chance to review that document, and are you ready to proceed?
Yes.
All right, defense is your motion. You may proceed.
Thank you, Your Honor. Pursuant to Rule 104, we're asking that we call Mr. Angel Delgado for the limited purposes of this hearing.
All right, Mr. Delgado, if you could unmute yourself. If you could
Okay,
raise
Your
your
Honor.
right hand. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All
Yes, Your Honor.
right, you can lower your hand. Could you state your name for the record and spell it, please?
Angel Delgado, ANGEL DELGADO.
All right, defense.
Thank you, Your Honor. May I inquire? Mr. Delgado, how long have you been in jail?
Over 2 years.
Now, this court, you had an entry on this court had sentenced you to prison. Is that correct?
Yes, sir.
Okay. And have you completed that prison sentence?
Yes, sir.
Okay. So in this case, in particular, you've been sitting in Bexar County Jail.
2 years, sir.
Okay. Now, do you have a residence here in Bexar County, Texas?
Yes, sir.
And what is that address?
839 Lee Hall.
Okay. And do you live by yourself?
No, I live with my uncle and my grandfather.
Okay. Does your uncle own that house?
No, we've been renting it for over 9 years.
Okay. Just listen to the question, okay?
Yes, sir.
Does your grandfather own that house?
No, sir.
Okay. Do you own that house?
No, sir.
Okay. So you just mentioned you all rent that house together. Is that right?
Yes, sir.
Okay. Now, how does your monthly expenses work at that house? Do you split the bills or does that work?
Yes, sir.
Okay. Now, are you married?
No, sir.
Do you have any children?
Yes, I have a son that I have custody of.
Okay. And where does that child live?
With me, my uncle, my grandfather.
And who's watching that child right now?
At the moment, my uncle and my grandfather.
Okay. Do you support that child when you're not in jail?
Yes, sir.
Okay. Do you have before incarceration? Did you have a job?
Yes, sir.
If you were to be bond reduced and been able to make that bond, would you have a job?
Yes, sir.
And what kind of job is that?
Remodeling houses, subcontracting.
Okay. And do you work with any family members in that job?
Yes, sir.
Okay. And who is that?
My uncle and my grandfather.
Okay. Thank you. Now, what is your bond set at currently?
80,000.
Okay. Now, have you been able to make that $80,000 bond?
No, sir.
Okay. Have you spoken with any bond companies regarding that bond?
Yes, sir.
Okay. And what is the minimum amount that bond companies would take to bond you out?
They wanted 2,000 for the 80,000.
Okay. Have you been able to meet that $2,000?
No, sir. My family's been scrambling, trying to, but we haven't been able to.
Okay. Well, now that you mentioned your family, as who's out there trying to accumulate funds to reach your bond?
My mother, my grandfather, my uncle.
Okay. Do you own a vehicle?
No, sir.
Okay. Did you own a vehicle?
I had a long time ago, but no, sir. Been here for 2 years.
Do you have a savings account?
No, sir.
Do you have a checking account?
No, sir.
How long have you lived in Bear County?
All my life.
Do you feel this bond is too high?
Yes, sir.
Okay. Do you feel it's a form of punishment?
I mean, I guess in a way it is, sir. I mean, it could be.
Okay. Does the home at 839 Lee Hall, does it have a home phone?
No, sir. I have phones, but not a home in the phone in the house.
Okay, so if the court was to want to monitor, would you make some type of arrangements to be able to abide by that condition?
Yeah, I'll get a phone that day.
Okay. Thank you, Judge. We'll pass the witness.
All right. State.
I have no questions.
All right. Any other witnesses, defense?
No, Your Honor.
State, any witnesses or evidence?
Yeah, I'll forward Stakes Exhibits 1 and 2. Exhibit 1 is the arrest affidavit, and 2 will be just a criminal history report. It should be coming through to
All right,
everybody.
thank you. And I'll give you a chance to review that, Mr. Porter. Everyone, just give me a moment. All right, we're back on the record. Defense, have you had a chance to review state exhibit? Which exhibit is this, state?
It's 1 and 2. The affidavit is 1 and the criminal history is 2.
Defense, have you had a chance to review those documents?
Judge, I did not receive them via email, but just for brevity's sake, I do have a copy of that, if it is the same one, the affidavit for arrest on this case that I've already reviewed previously.
All right, and what I will do, it was sent to your Robert Porter. That's what's included in the email to me. Is there a different email address? If there is, I will forward it to you.
Oh, there's no, that's the email address, Judge.
Okay, let me see if I can forward it from my email. Maybe it will come to you.
Okay, hold on. They just came in.
All right, I haven't opened the attachments, so let me know if you have any objections to those attachments.
Judge, the only objections obviously we're going to have is that it contains hearsay. And so we'd object on that.
All right, then those objections will be overruled. State's exhibits 1 and 2 are admitted into evidence for the purposes of this hearing. State, any other evidence or witnesses?
No, Judge.
All right, then the court will hear argument. Defense, it's your motion.
Thank you, Your Honor. As the court heard, Mr. Delgado has been in custody for quite some time now, in fact, over 2 years. The bond is set at $80,000. The evidence shows that he cannot afford that bond. And I know the affidavit that the court has read, we strongly don't believe these allegations. We are going to fight them. Mr. Delgado does have a child he would like to support. He also has a family network that he will be living with. He will show up to court on time and every time. Even when Mr. Delgado was not in custody, based on his criminal history, he was at court. So, Your Honor, we know that this bond is oppressive. It is a violation of the 6th and 14th Amendments to the Constitution. It is also oppressive. And so we therefore would ask this court to set this bond at a reasonable amount and with the conditions this court may see fit.
All right. And defense counsel, the 2 years that he's been in custody, was that because of his sentence on a previous case? Or he has actually been in custody since he's been sentenced on another case?
It's my understanding when I did the numbers, Judge, when this court, it was this court that had sentenced him to the 5 years. We did the math. He had a lot of back time on that case. So he was basically already eligible and finishing up that 5 years when he was sentenced there. And then he was picked up on this case on a warrant, and he's been sitting in jail on this case. That is
all right. State?
Judge, we just oppose the bond reduction. I think just the nature of the allegations and the criminal history alone show a need to protect the public.
All right, defense, it's your motion, so I'll give you a final argument.
Again, Judge, there's the allegations are egregious. We understand that, and I would like Mr. Delgado to be able to come to my office and work on these allegations. We've already done some investigation on this, and I don't want to get into the facts of the case, obviously. But this is going to be a trialable case, Judge. He does have a job waiting for him, and we would respectfully request it. We're not asking to waive the bond. We're just asking it to lower it to maybe half or maybe even $50,000 to be able to make it this bond. So he can aid his attorney in the preparation of his defense, and he's not sitting in jail all this time.
All right, the court will grant the motion. The court will set the bond at $75,000. Court will order GPS, and the court is ordering full GPS. Court will waive fees. And the court will note that the defendant has been in custody for 2 years. Is there anything else?
Not from the state.
Not from the bench, Your Honor.
All right. And with regards to this case, your jury trial date was set. However, because of the suspension of jury trials, we were unable to do that. So, Mr. Porter, have you received all the discovery in this case?
I have, Judge, and actually I have received a trial date on this case.
What date?
It's set for November the 17th.
Ah, you're right. I can't, it's bad when you can't read your own writing.
He wasn't on the docket. It was just on the docket today for this reduction, Judge.
Oh, okay. All right. I see that it is November 17th. So we'll see you back for jury trial on November 17th, Mr. Delgado. The instructions are the same instructions I gave you at that time. Your trial date will be November 17th unless jury trials are suspended. It'll be at 9 a.m. in the 187 District Court. If you're on bond, you will need to appear in court dressed for trial on that date. If you're in custody, you will be brought over from the jail. Do you understand? You need to unmute.
Yes, Your Honor.
All right, and when is your jury trial date?
November 17th,
What time?
9 a.m.,
Which court?
187.
All right, thank you. With that, the hearing is closed. Do you need to speak with your client anymore, Mr. Porter?
If I may, Your Honor.
All right, after you finish conferring with your client, please have him come back to the main room so he can be excused.
Thank you, Judge.
All right, I'll send you all to breakout room number 5. All right, thank you. Everyone, just give me a moment. All right, everyone, thank you for your patience. Let me see if I have all the paperwork.
Judge, I send you a chat.
Mr. Jerry, can you unmute yourself?
Yes.
Hi, how old are you?
50.
I'm sorry, how old are you?
50.
All right. Has a doctor come see you to speak and give you your evaluation?
Yes.
All right, so who's your attorney?
I am Judge Miguel on this. I don't know who he is.
Oh, well, I'm telling you right now, it's Miguel A. Hernandez. That is your attorney.
Well, he haven't never came to see me and talk to me, so I don't know who he is.
Guess what? We're all here now, so he can speak to you now.
Judge?
Yes.
I have attempted to speak with him. He does not want to communicate with me. He says he's in the process of hiring another lawyer. I don't know if that's true, but I tried to communicate my conversations with the assistant district attorney.
It was true.
Wait, time out. Mr. Derry. Mr. Derry. Here's the thing.
Yes, ma'am.
I require everyone to treat everyone with respect. So number one, what that means is one, there's no raising of voices at each other because when people are shouting, no one can hear. Number two, when someone is speaking, you wait till they're finished speaking. You do not interrupt. And then if there's something you wish to say, I will give you a chance to say that.
Yes, ma'am.
Now, Mr. Hernandez.
Yes, Your Honor.
Yes.
Because of Mr. Deary's attitude towards me, it seems like we have a conflict of personalities in the matter. And if he at this time needs another attorney, I would not be opposed to the court appointing someone that he feels he can better communicate with her, because he and I just don't seem to be able to communicate well at all, Judge.
All right, well, Mr. Deary, I believe, speaks English language. You speak the English language. So,
Yes,
Mr. Deary, why are you not speaking to your attorney? Here's the thing.
I tried. I tried like you asked me to.
Here's the thing, Mr. Deary. Speaking to an attorney or communicating with people, there's no such thing as I tried. What it is you tell somebody what you want, and they will either say yes or no. I can speak to somebody and say, I would like you to edge my lawn, to wash my car, and I would like you to do all of that for $20. And guess what? If they tell me no, I will only do that for $120. Guess what? We've communicated. I just don't agree with what they're offering. In all of these cases, I've been a defense attorney, I've been a prosecutor. Guess what? The defense attorney will review all the evidence. They will go to the state. They will speak to the state. The state will give them an offer. The defense attorney will give their client that offer. You can either accept that offer or reject that offer. But it is not good for you to get angry and close off communication with your attorney because you do not like that offer. All you can say is, I'm not accepting that offer. I want a jury trial, or either you can say, I'm not accepting that offer, but this is what I will accept, which is what's called a counter offer. Then what will end up happening is your attorney will go to the state with a counter offer, and the state can say yes or no. And then your attorney will come back to you with the state's answer, and you can either accept it or go to jury trial. But what we're not going to do is we're not going to let people have their picks and chooses of different attorneys, because that's not the way it works. There's a wheel system. Attorneys are on the wheel, and the attorney who comes up, that's your attorney. And if you want to hire an attorney, you're more than welcome to hire one. But what you don't do is you don't come to court, you get an attorney and you say, I don't like that attorney, I want another attorney. If you want an attorney of your choosing, then you need to retain an attorney of your choosing. Do you understand, Mr. Deary?
Yes, ma'am.
So, do you want to speak with Mr. Miguel Hernandez or not?
I can speak? Can I speak?
I asked you a question.
Oh, okay. I ain't very smart, but I ain't the dumbest person in the world. I know good attorneys from bad attorneys.
I never accused you of being a dull knife in a cutlery drawer. I never accused you of that.
I am pretty much a nutcase. You know, I am a, you know what I'm saying, psych patient on the cool.
Well, don't claim things for yourself. Don't, I
but
always
that's the
tell
truth.
people, never claim bad things for yourself.
But I have enough sense to know the difference between a good lawyer and a lawyer that ain't
Here's
trying to
the
help.
thing, Mr. Deering.
I done been through this.
Mr.
2
Deering?
times. Yes.
I do not allow people to speak badly of other people on Zoom. If you
ma'am.
want to express yourself, the issue is, do you want another attorney, which means that you will retain an attorney, or do you want to keep the attorney you have? Now, if you have family members, or if you have someone or yourself that is going to retain an attorney, of course, you're more than welcome to do that. But the people who pay for attorneys are taxpayers.
Hello, where you at?
Yes, I'm here.
I just made bond, which he said he doubted I was gonna make. And
Well, if you've made bond, you wouldn't be in custody.
Without the bond reduction, yes, I got out, but I can't, under certain circumstances, I came back. But he doubted me the first time, just like he doubted me now, saying I can't get no lawyer.
Well,
And
here's the thing.
for him to say something like that to me.
Here's the thing. There are some people who will tell their
ain't for me.
attorneys they're not going to be able to make a specific bond. But the fact that your attorney may or may not have told you that he didn't think you could make a bond, that has nothing to do with the price of peaches. We're here for your specific case. I'm going to give you a reset date. And if you're going to hire an attorney, then you need to have one hired by that time. Norma or Mr. Deary, can we have a 30-day reset?
October 7th.
All right, we'll see you back on October 7th.
One more thing, Ms. Boyd, Judge Boyd. What's going on with my psychological evaluation?
All right, we're going to bring you back on October 7th, and you can talk, if you will speak with your attorney and communicate with your attorney, then your attorney will be able to discuss you that with regards to your psychological evaluation and the results of that.
He don't even know nothing about it.
Judge, I've got a copy of the report. I will go meet with him on a RAV meeting and I will show him what exactly they said. But yes, we had a hearing on that. I believe it was at the end of last week. And he was found competent to stand trial.
All right, thank you.
Thank you, Judge. May I be excused and I will go see him.
Yes, you're excused.
Thank you, Judge.
Norma, can you let them Deary L13 can go back, please?
Yes, ma'am.
All right, Mr. Delgado.
Yes, Your Honor.
Just one moment. Who's your attorney?
Robert Porter.
All right, so I believe Mr. Porter, are you done speaking with Mr. Delgado? All right, Mr. Delgado, they will take you back now. Norma, can you let them know that 17C can go back?
All right, thank you, Your Honor.
Thank you. Have a great rest of your day.
Thank you, Judge.
Thank you. Have a good day.
Judge, I'm back
Attorney
from-
Jimenez.
Judge, I'm back from the 290th. I need to get to a breakout room to talk to a prosecutor.
All right, and who's your client?
It's Mr. Hinojosa Bonifacio.
You say it's criminal child abuse?
It's a family violence. It's a sex assault.
Okay, let me. I'll send you to number 2. And I believe we do have some paperwork that's coming in. Clerks, do you have paperwork on Jackson? And where are we on Roger Perez and Tyrese Smith?
Judge, can you put me in the breakout room with Addison Elliott? I have paperwork.
Miss Elliott, I'm sending you to breakout room number 1.
Thank you.
And could a family violence prosecutor go to breakout room number 2, please? And Richard Langlois, do you have the paperwork on Allison? Elliott Allison? All right, I'm going to send you and Sharon to breakout room number 1 just to make sure that they have all the paperwork.
Okay.
Bill Davidson? What is happening with Mr. Jackson?
Judge, do you know if Ponce is on, or I see his name is on here, but the screen is off.
Okay, let me find him. All right, Norma, can you check on Ponce? He's 17A.
Yes, ma'am.
Mr. Davidson, have you received all the paperwork on Jackson?
I haven't received any paperwork on Mr. Jackson yet. I don't know where it is, and I'll have to check my email, Your Honor. Let me check my email. I'm sorry.
Okay, and I put you in breakout room number 4, but we'll find out where your paperwork is.
Okay. I'll check on it.
Mr. Ponce, why was your screen off?
I have no idea. I was asking the people the same thing. They said that I wasn't put on yet. It's a different staff that's running the show today.
All right, okay, thank you.
I just need to go in a breakout with him. He was called for me, Judge.
All right, Mr. Ponce, I'm gonna send you to breakout room number 3.
She wants me to go to breakout room number 3.
And Roger Perez, what is happening with Tyree Smith?
We have signed the documents, Your Honor. And I think we just need the Zoom permission and the certificate, but I think we're all signed up, I think.
All right, and what is your case number?
It is 2020 CR 5441.
All right, and I don't know if your client has signed anything because I haven't received any paperwork.
I think he just signed because I'm with him in the conference room, and I'm going to put him on the screen here in just a second.
All right, to the clerks, I need 2020 CR 5441.
Judge, it looks like it was signed about 2 minutes ago, so it should be in Lupe's inbox.
All right, thank you. Brenda, we are very close. And also, all right, Tony Jimenez on Miss Hinojosa.
Yes, Judge. I spoke with David Martin on it, and there's a lot of discovery. I just recently got appointed by the court. So we're just going to review all of what is in the documents contained in the prosecution guide. So I just need some additional time, Judge.
All right, Norma, on Hinojosa, can you give him a 30-day reset, please?
October 7th.
All right, we'll come back on October 7th to make sure you have all the discovery. Mr. Hinojosa, we'll be back on October 7th.
Judge, he's a Spanish speaker. Could I go to a breakout room with him? And then do we come back to be excused or?
Yes, he'll need to come back to the breakout room to be excused. And can you let him know what his date is?
Yes, Judge.
And I'll make sure I put on the file that he needs an interpreter. Oh, Tony, can you let him know to go to the breakout room?
Yes, yes, Judge.
And it's number 2.
All right.
What's his name? Just read it to me one more time. R-E-S-E.
That's fine.
Oh, that's right.
All right, and Roger, we've received your paperwork. So I'm going to send you and your client to breakout room number 1. To make sure that all the paperwork is there.
Okay, I think we're just waiting for the paper. Okay.
And Tony, if you want to let him know in Spanish to go to breakout room number 2.
Judge, is he, he's in jail, so
Yes.
how do I connect up?
No. Just, he's on the screen right now. I've already assigned him and you to number 2. I just need you to tell him in Spanish because my Spanish is not of that level to tell him that.
Okay. Señor Hinojosa. ¿Puede oír, señor?
Tell him to press the key, the longest key on the keyboard, the space bar.
Señor, con su dedo, aprende a pegar la board. Habla con una persona allá, un deputy, que usted necesita ayudar por esto. Señor, habla con una persona allá. Ellos pueden ayudar a usted. Is there any way the court could let them know to help them, Judge?
Yes, just a moment. They're sending him to number 2 now.
Okay,
So he's there.
thank you.
You're welcome.
Oh my gosh. No, I won't.
It happens. Are you on a phone, Tony? All right, we're ready on Elliott. Who's the prosecutor on Allison Don Elliott?
I am, Judge.
Thank you. Yes.
Is Richard back, Your Honor?
I don't see Richard.
There he is.
There he is. Court is calling 2021 CR 5900, State of Texas versus Allison Don Elliott. Could I have parties announced for the record for the state?
For the state.
For the defense? You're on mute.
You're on mute, Richard.
Richard Lang for Allison Don Elliott, Your Honor.
And Your Honor, this is Sharon Thorne. I was also, I'm sorry. Go ahead, Richard.
Yeah, that's her true name. I think they had another name on there, an alias.
And this is Sharon Thorne. I represent her on 2 other cases, Your Honor, and they're going to be taken in consideration. So Richard represents her on the case that she's pleading to.
All right, and Mr. Langlois, you said there's an issue with the name. What is the issue with the name?
Your Honor, she has an AKA, I believe, and it's showing up sometimes as Allison Elliott is her correct name, but sometimes in the system, it's coming up under Leticia Dawn Vasquez, which I believe is her AKA. So I don't know if that should be added as well to the name line of the paperwork.
Yes.
Let me get this.
Any objections to the court adding in the style of the case, the AKA name of Leticia, Letehsia, Dawn, DAWN, Vasquez, VASQUEZ. Any objections from the state or the defense?
No, Your Honor, thank you.
Not from the defense, Your Honor.
No, Your Honor.
And are you Miss Elliott?
Yes, ma'am.
All right, and are you also using the name Leticia Dawn Vasquez?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
No, Your Honor.
Miss Elliott, I'm going to show you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Elliott, I'm going to show you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Next, I'm going to show you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on an indictment as presented?
Your Honor, the state waives count 2 of the indictment. We will be proceeding on count 1.
Any objection?
No, Your Honor.
Ms. Elliott, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand what you're charged with is theft of a vehicle, $2,500 to $30,000? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
That would be my opinion.
Ms. Elliott, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on count 1, waiving count 2. They're asking that your punishment be assessed at 2 years in the state jail facility, $1,000 fine probated, recommend community supervision. They will take in consideration the following cause numbers: 2021 CR 6036, 2021 CR 6037. There's to be restitution of $500 to Elizabeth Morin, Morin. There's to be no contact with Elizabeth Morin or 130 Wauh Street in San Antonio, Texas, 78223. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm going to show you the paragraph entitled Waiver Repeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There were none, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, 120 hours of community service restitution, the CATS theft course, and parenting classes and regular UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense is charged in count 1. How do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence to support the defendant's plea?
State offers State Exhibit 1 and all attachments.
Any objections?
We have no objections, Your Honor.
Ms. Elliott, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes, Your Honor.
Did you understand today that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments in the court were reviewed the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, one thing we'd like to address is that with the TAP evaluation, would that be performed after she's released from jail?
No, I will do a TAP evaluation during this hearing.
When?
I'm going to do a TAP evaluation right now.
Okay.
Okay.
That'll be fine.
All right, anything you wish to say on behalf of your client?
Judge just asked that you follow a plea agreement. The reason she wanted a TAP evaluation immediately is that she has a son that she can visit either Friday or next Monday, and she's in a CPS program to make sure to allow her to get back custody with her child.
All right. Miss Elliott, why were you in this person's home?
Why was I in her home?
Yes.
I wasn't in her home, ma'am. She had given me permission to use the vehicle.
Nope. I've read the police report, and the police report says that the victim came home, didn't think anything of it, but her cat was staring at something, and it was you. And then what it says is you leave because you said, oh, your son gave me permission to live here or to come over. And the victim says, no, she lives right across the street from me. So she told you to leave. You leave, and then she goes outside and she notices that her truck is gone. So let's start back over. How long have you been using drugs?
I was clean I got clean in 2019, and then I relapsed in December of last year.
And what were you using?
I was taking Xanax.
And what else?
That's it.
How old are your children?
They're 7 and 2.
All right, and where were your children during this relapsing?
At home.
With you?
With my mother-in-law, yes, ma'am.
So why were your children with your mother-in-law and not you?
Well, I was living there. We were living together, ma'am.
Who's your CPS attorney?
I have all my stuff. It's Michelle. I have all my stuff written in my Bible.
No, I'm just asking questions. Who's
Okay.
your CPS attorney?
I don't know her name. Like, it's written in my Bible. I'm just in the beginning of my CPS case.
Okay. Who's your CPS worker?
Olivia.
Olivia what?
Olivia, it's a weird Hispanic last name with a B.
Right.
I have all my information in my Bible.
How long has your CPS case been going on?
Since I've been arrested.
And how long has that been?
Since December of last year.
Ms. Thorne, I know you practice CPS, as have I. Is there still an open CPS case? Since
I was not able to confirm that, but based on what my client tells me, she does have an open case. And she also has a service plan. So part of that service plan is parenting classes, and I know that part of this plea bargain called for parenting classes. I would ask that either she does parenting classes through probation or through the service plan with CPS.
Okay, I'm just finding it hard to believe that her CPS case is still open from 2020 and we're in 2021. But maybe it happened.
That I don't know, but she would normally, you're right, normally there would have been some sort of a hearing by now as to at least a 6-month or something going on.
Yeah, I had my adversary hearing. I have 18 months to do what they're asking me to do to get my son back.
When was your adversarial hearing?
It was in February, ma'am.
Okay.
It was in February.
All right. Have you ever been employed?
Yes, ma'am. I worked for Gerling Home Health Care
When was the last time you were employed?
last year.
Okay. All right, this is what the court is going to do. $1,000 fine, that'll be probated. Sentence you to 2 years in the state jail facility, suspended and probated for 3 years. Take in consideration 2021 CR 6036, 2021 CR 6037, restitution of $500 to Elizabeth Moran, no contact with Elizabeth Moran or 130 Wall Street, San Antonio, Texas, 78223. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or any employment involving minors. CATS theft course. They want to give you a theft course to tell you not to steal. I can give you a theft course in 2 minutes. Don't take what doesn't belong to you. Don't go to inside any buildings or homes unless you're invited. But I'm still going to order the CATS theft course. Parenting classes. 120 hours of community service restitution. 40 hours will be waived if you obtain the COVID vaccine. Whether you get the vaccine or not, that's completely up to you. I'm not ordering you to do it, but if you do it or if you have done it and you provide proof to probation, they'll waive 40 hours of your community service restitution. If you have parenting classes through CPS, of course, that will be acceptable. I don't want duplicate services. I'm going to have CPS compliance. Are you able to Zoom? Do you have a phone, a cell phone?
Yes, ma'am.
All right, there's going to be Zoom reporting, regular. If you are not able to Zoom, then it will need to be in person. So if you wake up one morning and there's a problem with your ability to Zoom, you're going to have to report in person.
Yes, ma'am.
And with her, I'm going to do the UA hotline and intensive outpatient treatment with probation. And Rebecca, let's go ahead and put her on the wait list for felony drug court. If they, Ms. Thorne and Mr. Langlois, if CPS puts her in their drug court program, then that will be acceptable to the court. And if she's in their drug court program, then Rebecca, we won't need to do intensive outpatient treatment or put her on the wait list for felony drug court. I'm going to want field visits, random, 2 times per month. Rebecca, is there anything else that she needs?
No, ma'am.
Ms. Elliott, is there anything else that you need from the court in order to be successful?
No, ma'am. Thank you so much.
All right, you're welcome. I'm going to show you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Ms. Elliott, I wish you best of luck. I will tell you this, Ms. Thorne has done plenty of CPS cases. I've done plenty of CPS cases. In order to be successful, communication is key. You should be able to name your CPS attorney by heart and have their phone number by heart. Your caseworker, you should know their name by heart and you shouldn't be able to recite their phone number by heart. This is very serious. They have deadlines on that side. Children don't get to choose who their parents are. So treat your children like the precious jewels that they are. And if you're not going to do what needs to be done as a parent in their life, then maybe you need to keep it moving because they're depending on you. And what I can tell you is CPS cases, every time a parent has a visit, and they won't let you have a visit if you're not clean, they'll tell the children that there's a visit coming up. And when you don't show, that breaks the child's heart each time you don't show. Then it gets to the point where they don't trust their mom and they're just like, yeah, she's never going to show. So show up and get clean. All right.
Yes, Your Honor.
If you couldn't do it, I wouldn't have placed you on probation.
Thank you, Your Honor, for believing in me.
You're welcome. I'm going to send you to breakout room number 2. Probation will go over conditions with you. And Mr. Langlois and Ms. Thorne, you can go to number 2 or either you can be excused.
Judge, I have a question.
I'm sorry, just one moment. Yes, Rebecca?
Is the felony drug court while in custody or no?
No.
Okay.
I want her to get out so she can start working her plan because they're on deadlines over there. Which means, Miss Elliott, everything that I'm asking you to do, you need to make sure you do it because if you don't, there's going to be a warrant that's going to be issued. And when a warrant gets issued, as you can tell, you're taken into custody and that takes away your time from completing your CPS case.
Yes, ma'am.
All right, thank you. If you all can all go to number 2 and attorneys, as I said before, you're excused, but if you want to go to number 2, you're more than welcome to.
Ms. Boyd, Judge.
Yes.
So do I go in the room to do my TAP evaluation?
No. I've already given you your TAP evaluation.
Oh, okay.
Yeah.
Sorry, I'm sorry.
No, I found out what your drug history is and I do what I think is appropriate, but you're going to go to number 2. They're going to go to conditions with you. You should probably be released from custody, hopefully before 1 a.m., but usually it's like 1 a.m. or midnight.
Okay, thank you so much, Ms. Boyd. I appreciate it.
All right, you're welcome. Have a great rest of your day.
You too.
Thank you.
God bless you.
Oh, thank you. God bless you too.
Oh.
All right, Tony Jimenez.
Yes, Judge, I conferred with Mr. Hinojosa and I told him that we were going to be back October 7th.
All right, thank you so much.
Thank you, Judge.
All right, have a great rest of your week. Be safe out there.
You too.
All right, thank you.
Bye-bye.
Bye. All right, to the clerk, you should be receiving paperwork on Mr. Jackson. And Norman, can you let them know that 17B Hinojosa can go back?
Yes, ma'am.
And Mr. Jackson, I'm going to send you to breakout room number 1.
Okay, thank you.
Yes, and Mr. Davidson, I'll send you to 1. And Norma, on Orlando Armas Ramirez, let's just have that come back at 2 for his plea.
Okay, Judge.
And if you can have an interpreter here.
Okay, Judge.
Judge, this is Bill Davidson. Just so you should know, I have already gone over all the paperwork with my client and he signed it, just in case you know.
All right, thank you. No, I sent him to breakout room number 1 and I sent you to 1 so that he could be sworn in.
Gotcha.
All right, thank you. Deputy Laura, could I see you in the back, please?
And Judge, we just have 2 pleas. We just have the interpreter one and the one with Roger. That's it.
Yes, and also the one with Bill Davidson.
Oh, okay.
Yes, and that will be it.
Hey, guys.
Hi, Miss Cruz, do you have all of the paperwork?
We should. I'm sorry, there was a delay. Hunter had to upload the correct offense report, but we signed, defendant has signed. I'm hoping we're.
Norma, then we may be able to do this plea before 12:30 then. Do you think you could get the interpreter? I'm trying to see where the other paperwork is though.
We signed, Norma sent me her stuff earlier. We signed that earlier, and then Hunter just sent me his stuff right now at 11:50, but we signed that as well.
Okay, what I'm gonna do is I'm gonna send you to a breakout room. I'll send you to breakout room number 1 and we'll see if we can discover where the paperwork is.
Okay, yes, Your Honor.
And I'll send your client to number 1 as well.
Yes, ma'am.
Paperwork should be coming, Lupe. Is everyone okay if we stay a little bit late to finish up the other 2 cases and then we won't be back for the afternoon?
Judge, with Brenna's blessing, I'll stay as long as you need to do these pleas.
Okay.
I give it my blessing.
All right. Thank you. I appreciate that.
In the words of Sunday school, amen, amen, amen.
Thank you, Roger. So we have Roger's client's plea. And we have Victoria's plea that's going to require the interpreter. And then I think we have one more, Jackson. And so as soon as I receive the paperwork on that, we will go forward.
And Judge, I just forwarded the signed paperwork for Victoria's client.
All right, thank you. And they are all in breakout room number 1, so they'll be sent in as soon as they're done. Just 1 second. All right, are we ready on Mr. Hilliard?
Yes, Your Honor.
Who is the prosecutor on Therese James Hilliard Smith?
Hunter Morris, Judge.
Thank you. All right, the court is calling 2020 CR 5441, State of Texas versus Therese James Hilliard Smith. Can I have parties announced for the record, please, for the state?
Hunter Morris.
For the defense?
Roger Pettis for Tyrese Hilliard James Smith, Your Honor.
And are you Mr. Hilliard Smith?
Yes, ma'am. Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objections from the state?
None, Judge.
Any objections from the defense?
No, Your Honor.
Mr. Hilliard Smith, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
The court will find that the state is in compliance with discovery. Mr. Hilliard Smith, I'm showing you a document entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
Okay. All right, state, are you proceeding on the indictment as presented?
Proceeding on the lesser included offense, Judge, of assault on a peace officer.
Any objection?
No objections, Your Honor.
All right, Mr. Hilliard, I'm going to show you what's entitled Court's Admonishment and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it at all the appropriate places?
Yes, Your Honor.
All right, what you're charged with is an assault on a peace officer. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
All right, we're going to go off the record for a minute. Ms. Nero, thank you so much for buzzing in. I'm going to send you to breakout room number 1. And there's a defendant in there to be sworn in.
Yes, Judge. Good morning.
Good morning. All right, we're back on the record. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor. I understand.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hilliard Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault of a peace officer as a second-degree felony. There's a $2,500 fine. State recommends deferred adjudication. The state will take in consideration the following cause numbers: 2020 CR 5438, 659-190, 635-790. There's to be restitution, if any, to Sergeant Alonzo. There's restitution to Victor Rodriguez in 659-190. There's to be no contact with Sergeant J. Alonzo, Sergio Mendez, or Victor Rodriguez. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Two corrections, Judge. One,
Yes.
the state does not object to defense asking for a probated fine. And two, on the causes taken into consideration, the third cause listed is 635-796.
Okay, thank you. So the cause numbers are 659-190 and 635-796?
Yes, Judge.
All right, thank you. With those corrections, do you understand that to be the plea bargain agreement, Mr. Pettis?
Yes, Your Honor. And
Mr.
indeed, we are
Hilliard?
asking if you could consider a probating of the fine.
All right, and the court normally does probate the fine unless there's an extraordinary reason why it should not be probated. Mr. Hilliard Smith, did you understand that to be the plea bargain agreement with the corrections that were stated on the record?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver Repeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be granted for 5 years. There be a TAP evaluation, 150 hours community service restitution, MILF evaluation, and anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense of assault on a peace officer as a second-degree felony, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
State offers states one and attachments, Judge.
No objections, Your Honor.
Mr. Hilliard, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it? And all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
All right, Mr. Hilliard Smith, why do you have that screen up where you have the bubble that says, huh?
It was a random filter that was chosen. Take it off.
Just take it off. He's in my conference room, Judge.
No problem. Okay. All right. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. How the court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. He realizes he was going through a little challenging phase in his life. He's actually been evaluated and now all that is behind him. So we would appreciate if you indeed determined that the McMile case manager would be in charge, that would be sensitive to some of his previous concerns, but he's doing well. He's working full-time at a temp agency. He's got a GED. And so he's getting his life back on track. He's got a good full support system with his mother. And except for this morning's logistical problems, he's very prompt and responsible in responding to all the calls and needs in this particular case. So we would just ask that you could consider going along with the agreement, Your Honor.
All right. Mr. Hilliard-Smith, what are you doing to help yourself with any type of mental issues that are happening in your life? Are you seeing anyone?
You said, am I seeing it?
Are you seeing a therapist or someone or no?
Not at the moment. I'm just, just taking my problems with a grain of salt, just trying to evaluate them and, elaborate, get to the solution of the problem instead of reacting in a way that is not civilized.
All right. Well, here's the thing, Mr. Perez. There is no harm or no shame in admitting you need some help. At some point in time, everybody needs somebody. You can pretend like you don't, but we all do. But the issue is recognizing that, because I want to make sure that the reason you're here today doesn't happen again. You understand?
Yes, Your Honor.
All right. So do you live with your mom?
Yes, ma'am.
What do you do for work?
I'm at a temp agency, random events. Wherever they call me, I go, and that's how I get paid.
Okay, what kind of events have you been doing? What are random events?
Yesterday, there was a soccer game and I volunteered to help out there and I got paid for that. Last weekend was a concert and I helped out with that. And yes, pretty much stuff like that, helping out, trash, janitorial services.
You get to become a jack of all trades. All right, this is what the court is going to do. $2,500 fine. And Mr. Perez, I'm going to need you to write down everything I'm saying because the probation officer is in a breakout room. So far, there have only been 2 attorneys who have been able to go to the breakout room and tell probation exactly what I said. One of them was Nathaniel Navy. So, Mr. Perez, don't disappoint me.
We'll try.
Okay. So, a $2,500 fine that will be probated, 5 years deferred adjudication, take in consideration 2020 CR 5438, numbers 659190, 635796, restitution to Sergeant J. Alonzo, if any, restitution to Victor Rodriguez, and 659190, if any. No contact with Sergeant J. Alonzo, Sergio Mendez, or Victor Rodriguez. MIC evaluation, anger management, 150 hours of community service restitution. 40 hours of those will be waived if you obtain the COVID vaccine. I'm not forcing anyone to get the COVID vaccine. You don't have to get it if you don't want to, but if you've already received it or if you're getting it, then 40 hours of the 150 hours will be deducted. There's to be regular reporting by Zoom. If something happens and you're not able to report by Zoom, then you'll need to report in person. We're going to do random field visits, one time per month. Proof of employment within 30 days. There's to be no employment as a home health care provider or supervision of minors. And Mr. Perez, you can let Rebecca know if Mr. Hilliard Smith sees therapists. For every hour of therapy he receives, I will deduct an hour of community service restitution. So, and that's a mental health therapist.
Great.
And then there is to be regular UAs, or either he can do the patch. All right, Mr. Hilliard Smith, is there anything else you need from the court in order to be successful? And sometimes the answer is no, but here's the thing, communication is key. And sometimes when I order things, because I don't give people cookie cutter conditions of probation. Everybody's an individual. Everybody has slightly different conditions that I give them. So I'm just asking you, is there something that you need from the court that I have not ordered?
Oh, no, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you, Mr. Hilliard. I'm going to send you to breakout room number 2. Probation will go over conditions with you. Mr. Perez, do not disappoint me in that room.
I'm gonna do a good job, Judge.
All right, thank you. I appreciate it. Have a great rest of your week.
Thank you. Take care.
All right, Mr. Hilliard Smith, if you'll go to breakout room number 2, please. All right, who's the party on Mr. Joshua Jackson?
Hunter Morris, Judge.
All right, the court is calling 2021 CR 7496, State of Texas versus Joshua Paul Jackson. Can I have parties announced for the record for the state?
Hunter Morris.
For the defense?
William Davidson.
And are you Mr. Jackson? Could you unmute for me, please?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
None, Judge.
Any objections from the defense?
No, Your Honor.
Mr. Jackson, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review that discovery with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Jackson, I'm going to show you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Proceeding on count 1, evading judge, waiving count 2, felon in possession.
Any objection?
No objection, Your Honor.
Mr. Jackson, I'm showing you what's entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand what you're charged with, evading arrest or detention in a vehicle? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Jackson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, state is proceeding on count 2. Punishment is to be assessed at 3 years in the prison. There's a $1,000 fine. There's no application for deferred adjudication. State recommends community supervision. State will take in consideration cause number 656921. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Judge, it sounded like you said count 2. The intent of the state is to proceed on the evading. I believe that was count 1.
Okay, I think I said count 1 and count 2 was waived.
Okay, great.
All right, thanks. All right, Mr. Jackson, I'm gonna show you what's entitled Waiver Repeal. Did you review that document with that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, 150 hours of community service restitution, drug court referral, DWI education, DIP, regular UAs, defensive driving or driving safety course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 1, evading in a vehicle, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
State offers states one and attachments, Judge.
Any objections?
None, Your Honor.
Mr. Jackson, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client has told me that he's learned his lesson and that he's really tired of sitting in jail after the mistakes that he's made. And he knows that he's on thin ice here, being on probation. And I've explained that to him, that at any point he could get revoked. And at that point, that's all I have to say at this point, Your Honor.
All right, Mr. Jackson, do you have any children?
Yes, ma'am. I have 3.
What are their ages?
9 through 4, and 1 is about to turn 2 the next few days.
Where are they?
They're with their mothers.
How many mothers?
3.
Do you see them?
Yes.
All right, have you ever used any type of drugs in the past?
Yes.
What have you used?
I've used marijuana.
And what else?
I've tried meth, but I don't use that. No.
And what else?
That's it. That's it.
Here's the thing, if they're asking for you to be referred to drug court, it's more than marijuana. So you've already pled. I've already found there's sufficient evidence to find you guilty, and I've found you guilty of evading. Now is the time for you to communicate open and honestly with me, because I have to set conditions, and the conditions I give you are conditions so that you will be successful on your probation. If you have a drug problem and you're not honest with me, and I send you out into the world with no help for that drug problem, if you test positive, that's all you. If you tell me that there are issues in your past with drug addiction, and I send you out in the world and I don't give you help for that, then that's on me. I should have seen that coming. But I can't see anything coming, and I'm not going to try to see anything coming if you're not honest with me and tell me the truth. So sometimes this helps people because people don't want to make admissions. Hypothetically, what drugs would you have used?
That is it. That's in the past. Yeah, that's
I mean,
all
just
I've ever used.
hypothetically, what have you used?
Hypothetical.
Yeah. Just anything that you've tried.
Well, a while back I've tried cocaine, but that was about it.
So cocaine, marijuana, meth, anything else?
That's it. That's all that comes to my mind. That's all I know.
Xanax, heroin,
No.
anything like that?
I don't even pop pills. I don't even take aspirin.
You see, when you say you don't even take aspirin, but you've done meth, cocaine, and marijuana, it's sort of like doesn't compute, but okay. All right, Bill Davidson, I'm going to give your client his conditions. I need you to make sure you write all of this down because I'm going to need you to give it to probation.
Okay.
Do not disappoint me, Bill. The only attorney so far who's been able to go to that room and give her everything I say has been Nathaniel Navy. I'm going to see how Roger Perez does. Some people would go in the breakout room with probation, and probation says, they come back and say, I don't know. I think this is what was ordered. So if you could please write that down for me.
Okay.
So I'm going to sentence him to 3 years in the prison, suspended and probated for 3 years,
Okay.
$1,000 fine, probated. Take in consideration cause number 656921. 150 hours of community service restitution. 40 hours of that will be waived if you obtain the COVID vaccine or have obtained the completed vaccinated dose. I'm not forcing anyone to do it. You don't have to do it if you don't want to do it. But if you do, I'll deduct 40 hours from your community service restitution. I'll refer you to felony drug court. There's to be the DWI education course, DIP, defensive driving or driving safety course, regular reporting by Zoom. If you're not able, something happens and you're not able to report by Zoom, you need to report in person. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or any employment that involves the supervision of minors. Random field visits. Two times per month. And we're going to do the UA hotline. And Bill, add outpatient treatment with probation. Mr. Jackson, if you do well on outpatient treatment with probation, then felony drug court, you won't have to go there. You understand? So whether or not you have to go to that 2-year program depends upon your actions.
I understand, Your Honor.
Your Honor, the last one you gave me was outpatient drug therapy?
No, outpatient drug treatment with probation.
Okay.
And parenting classes. Mr. Jackson, is there anything else that you need from the court that I have not given you?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Jackson, you have 3 children. You need to
Yes.
do better for them. You understand?
Yes, ma'am.
And one of the rules of probation, they're going to tell you, you have to support your dependents. So you're going to have to support your children.
Yes. I
All right.
understand.
Okay. From here on out, everything you need, everything you do, you need to ask yourself, is this something that could result in me going to prison for 3 years? I'm going to send you to breakout room number 2. Please be patient. Probation will go over conditions with you there.
Thank you.
All right. Thank you.
Thank you.
God bless you.
Thank you. God bless you too. It's nice to receive blessings, Verna. All right. The last case we have is Aramis Ramirez. Who's the parties on this case?
I don't know where he went, Judge.
I'm
Oh,
here.
he's here.
I'm here.
Oh, I don't know why it's only showing.
Because I tried to charge my phone. It's only got 5% right now.
Okay,
But
we're ready.
I can find anywhere.
Okay. Let me change the interpretation, everyone. Oh, let me ask you this. Mr. Ramirez, are you able to change the interpretation on your phone?
Let me see what I need to do. Like a joint breakout room right there, or
No.
right?
I'm about to do it right now.
Okay.
Just 1 second.
Your Honor, I explained Mr. Armas Ramirez that he needs to look for 3 dots because he's
Oh, on
using
the
a cell
bottom?
device. Yes.
Okay, meeting setting, minimum background and filter. It doesn't say about the temperature on the
Yes,
bottom.
just give me 1 second. I'm adding her now.
Oh, okay, I understand.
All right, so if everyone will go on the English channel.
Okay.
All right, so,
I did it right.
all right, so here's the thing, Mr. Ramirez, either we're going to use the interpreter or we're not going to use the interpreter. If we're going to use the interpreter, then you need to speak in Spanish.
Sí.
¿Escucha Norma?
Yes, the court. All right, the court is calling 2021 CR 1477, State of Texas versus Orlando Armas Ramirez. Can I have parties announced for the record for the state?
Hunter Morris.
Victoria Cruz on behalf of Raymond Martinez for the defense.
Hunter, make sure you mute original.
Hunter Morris for the state.
And we have an interpreter here, Ms. Norma Nero. If you could raise your right hand for me, please. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and from Spanish into English, so help you God? All right, and are you Orlando Ramirez?
Okay. Sí.
We're proceeding by video because of the pandemic. Any objections from the state?
None, Judge.
Any objections from the defense?
No objection, Your Honor.
Mr. Ramirez, all of the documents that I'm going to discuss with you are in English. Were those documents explained to you in Spanish?
Correcto.
Ms. Cruz, are you a Spanish speaker?
I am, Your Honor.
And were you able to explain these documents to your client in Spanish?
Yes, Your Honor.
And do you believe that he has understood all of the documents?
I do, Your Honor.
Mr. Ramirez, did you sign a document entitled Defendant's Consent to Appear by Video Conference? And did you understand that?
Sí, claro.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Did you sign a document entitled Application of Community Supervision, and did you understand that document?
Sí, sí lo entendí.
Counsel, have you received all the discovery in this case, and did you review it with your client?
We have and we did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ramirez, did you review a document entitled True Bill of Indictment with your attorney? Did you understand it?
Sí, sí, sí lo entendí.
State, are you proceeding on the indictment as presented?
Proceeding on a lesser included offense, Judge, of theft from $750 to less than $2,500. It's a Class A misdemeanor.
Any objections?
No objection, Your Honor.
Mr. Ramirez, did you review a document with your attorney entitled Court's Admonishment and Defendant's Waivers and Affidavit of Admonitions? And did you understand it?
Sí, los entendí.
The state is proceeding on the lesser included offense of theft, $750 to $2,500. That's a Class A misdemeanor. The range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Sí, entendí todo lo que me explicaron.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Sí.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Sí, correcto.
Do you understand by entering this plea bargain agreement, you were giving up those rights?
Sí.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Sí.
All right, Mr. Ramirez, on the system, your attorney is listed as Raymond Martinez, but the attorney standing in for Mr. Martinez is Victoria Cruz. Do you have any objection to Ms. Cruz taking this plea?
No, no, ella me está representando bien.
All right, Ms. Cruz. All right, thank you. Ms. Cruz, for the record, could you state the reason you are you feel to stand in the place of Mr. Martinez for Mr. Ramirez?
Your Honor, I'm employed by Mr. Raymond Martinez as his associate attorney, and I am part of his firm.
Thank you. All right, Ms. Cruz, has your client been able to provide you with any defenses to this case?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he does, Your Honor.
Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, nadie.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Sí, claro.
Are you a U.S. citizen?
No.
Counsel, did you advise your client of the consequences of pleading no contest or guilty in the application of federal immigration law?
I have, Your Honor, if I may be allowed, I have 3 questions, admonishments that I would like to put on the record.
Yes.
Thank you, Your Honor. May I proceed?
Yes.
Mr. Admas Ramirez, we have advised you that there's a risk of deportation and denial of immigration benefits that carry with this plea, correct?
Correcto.
We have instructed you regarding your right and duty to consult with your immigration attorney regarding the specific immigration consequences of this plea, correct?
Correcto.
And you are entering into this plea with the understanding that we have conferred with your immigration attorney, Warren Craig, of the San Antonio immigration firm DMCA. And we have based this plea according to his specific advice for your case, correct?
Sí, correcto.
Last question. You are making the decision to enter a plea of no contest, understanding that you may be found guilty and that the immigration consequences of this plea may result in deportation, denial of naturalization, and denial of any other immigration.
Your client has left the screen.
Where did he go?
Yeah, so just give us a moment.
I was so close.
You were so close.
I did a ton of these writs, so.
He was looking for a charger, Judge, because he was at 5%.
I don't know why people come on the screen with 5%. I mean, when you're zooming, 5% will take up a lot of charge. Brenda, I have not been zooming on my phone, although my phone is very old, but I haven't been zooming on my phone. It was 100% when I came to the office. It's at 62%. But then I think they're on the number 20, and I'm still on number 6. This is the 6th generation. Over and over.
Judge, I send you a chat.
All right, thank you. So do we think Mr. Ramirez is going to be on here? Everyone, I know we were trying to finish before, so we wouldn't have to come back, but it appears, everyone, we may have to come back at 2:30.
I understand, Your Honor.
All right, so Ms. Nero, are you able to come back at 2:30 for us to finish this up? Oops, let me take me off. Let me do this off. Oh, I can't hear you. Oh. All right, see you at 2:30.
And we'll take it up where we left it off, or are we gonna start all over?
No, we'll take up where we left off.
Perfect, perfect. It'll be really
Okay.
fast. Thank you.
All right, thank you. Bye-bye. And everyone, we're gonna take our break. And I'm gonna stop live streaming. We'll